Thank you. I'll go ahead and call the 125th meeting of the Tennessee Advisory Commission on Intergovernmental Relations to order. Welcome. Thank you all for being here. First on the agenda today, behind tab 1, for your approval are the minutes of our July 2013 meeting. Thank you, Alice. Properly moved and seconded. Any corrections, comments, questions? Hearing none, seeing none, all in favor signify by saying aye. Aye. Any opposed or abstaining? All right, those minutes are duly approved. Behind tab 2, it's my sad duty to recount the fact that our member, our colleague, Speaker Pro Tem Lois DeBerry, passed from this life on August 28th of 2013. As you'll recall, she was here for our last meeting in July. She was present and accounted for and actively participating right to the end. We have behind tab 2 a resolution honoring Representative Lois DeBerry's memory, and I have asked that Mr. Lippard read that into the record, and if you would indulge all of us, as we do in the Senate, if you would all please stand while Cliff reads the resolution in her memory. Thank you.
A resolution to honor the memory of Representative Lois DeBerry of Shelby County. Whereas Representative Lois DeBerry was appointed to the Tennessee Advisory Commission on Intergovernmental Relations in March 2013 and served as a member of the commission until her death, it is fitting that the members should pause to remember the exemplary life of this extraordinary public servant and individual. And whereas Representative DeBerry graduated from Hamilton High School in 1962 and earned a Bachelor of Arts degree in elementary education from Lemoyne-Owen College in 1971, and whereas Representative DeBerry began her career in public service in 1972, serving as the first African-American woman elected to the House of Representatives from the city of Memphis, the first woman chairperson of the Shelby County Democratic Caucus, and founder and chairperson of the annual legislative retreat of the Tennessee Black Caucus of State Legislators, and whereas Representative DeBerry served as House member of the 88th through 108th General Assemblies, House Speaker Pro Tempore for the 95th through 106th General Assemblies, chairman of the Special Committee to study integration of ex-offenders into mainstream of society, and as a member of the House Education Committee, House Finance Ways and Means Committee, and House Finance Ways and Means Subcommittee, and whereas Representative Lois DeBerry also served as a member of the Health and Human Resources Committee, Government Operations Committee, Select Committee on Children and Youth, Committee on Rules, Oversight Committee on Corrections, Ethics Committee, Oversight Committee on TennCare, House Committee to Study School Safety Issue, Governor's Minority Business Development Advisory Committee, and the Governor's Juvenile Justice Reform Commission. And whereas, as a lifelong public servant and a source of knowledge and expertise in state government, Representative DeBerry was respected nationally by colleagues and constituents and lent her time and talent to a number of worthy organizations, including service with the National Association for the Advancement of Colored People and Delta Sigma Theta Sorority, service on the Board of Directors of the State Legislative Leaders Foundation and the Executive Committee of the National Conference of State Legislatures, and service as President Emeritus of the National Black Caucus of State Legislators. And whereas TACIR Chairman Senator Mark Norris, commenting on working with Representative DeBerry, said, "Hers is a great loss in our community. She will not easily be replaced nor soon forgotten. Her legacy is lasting." And whereas House Speaker Beth Harwell said of Representative DeBerry, Lois DeBerry dedicated her life to service from the civil rights movement to becoming the first female African-American Speaker pro tempore. Lois always made public service priority. The impact she has had on this great state, the lives of countless Tennesseans and people all across the country is astounding. She certainly made her mark on history, and it was an honor to know her and serve alongside her in Tennessee General Assembly. I valued our friendship and will deeply miss her sage advice and her remarkable spirit and smile, and her dedication to children's issues, women's issues, and criminal justice reform have resulted in a better Tennessee. Be it resolved by the Tennessee Advisory Commission on Intergovernmental Relations that we hereby honor the memory of Shelby County Representative Lois DeBerry, reflecting fondly upon her exceptional service to the people of Shelby County and the state of Tennessee, and upon her stalwart commitment to living her life with courage and conviction. Be it further resolved that we express our sympathy and offer our most heartfelt condolences to the family of Representative Lois DeBerry.
Thank you, Dr. Lippard. Chair moves adoption of the resolution. Is there a second? Properly seconded. As we stand, any who'd like to make additional comments? She was memorialized in a very special way. A number of us in this room were present for the service, and but the floor is open if there are any who'd like to say anything else. The resolution captures the essence, what we are otherwise unable to really put into words. Hearing none, then all in favor signify by saying aye, please. Aye. Resolution is duly adopted, and we'll present an appropriate copy of it to her husband and family. Thank you very much. Thank you for asking. We will move on to tab 3 at this point. I don't think I've overlooked anything there. And we are moving, as we get to tab 4, we do have a number of special guests today who will participate in the panel and testify before our committee. But behind tab 3, we do have Nathan Shaver here to talk to us about the background on the insurance versus surety bonds legislation issue. You're recognized, sir. Thank you. Thank you.
Good afternoon. I'm Nathan Shaver, a research associate at TACIR, and I'll be presenting some background information on our study of Senate Bill 624. Our draft report will be presented in October, and our final will be in December. Most of this presentation will summarize the use of individual surety bonds for public officials and how they function in our state, with a brief comparison to insurance near the end. Our research in the coming months will focus more on how the bill's proposed system could operate in other states' approaches. This bill would allow the optional use of insurance to cover public officials that are required under current law to have individual surety bonds. The bill was sent to TACIR by the Senate State and Local Government Committee with instructions to study whether insurance would be a suitable alternative to public official surety bonds. Tennessee law requires various local government officials to execute surety bonds in order to hold office. Table 1 on pages 4 and 5 of the memo lists these positions that require surety bonds, the corresponding Tennessee Code annotated statutes, the required minimum amount that the bond must cover. Most of these bonds amounts were recently increased this year through Public Chapter 315. The large majority of these positions that require surety bonds are at the county level. There are only 2 at the city, and there's no individual surety bond requirements at the state level. Some city charters also require individual surety bonds. In brief, these individual surety bonds are used to protect against loss up to the bond amount caused by a public official not faithfully performing official duties. The bond protects the state, county, and the citizens in the event that the county official fails to perform the duties of the office. It does not protect the official from liability. On pages 1 and 2, you'll see a short section on terminology. This was included because of the inconsistency and confusion surrounding some of these terms. For example, Tennessee's statute addressing a city manager's surety bond refers to it in some places within the statute as a fidelity bond, though it is not one, and those are 2 entirely different bonds. It's unclear whether this is a cause or the result of inconsistent use in the bond and insurance industries. So for clarity, I'll briefly go over some of the terminology. A public official bond is a broad term used to describe required coverage for a public official, traditionally used to enforce the faithful performance of official duties and to indemnify the public official against delinquency. The surety bond is a 3-party contract in which one party guarantees a second party the successful performance of a third party. In our context, this would be the surety bond company guaranteeing the county or the city the faithful performance of the public official. And if the public official does not faithfully perform the duties of office and the public official cannot pay for those losses on his or her own, then the surety company will pay the county or city for any losses caused by the lack of faithful performance up to the dollar amount listed in the bond. A key distinction is that the risk of loss stays with the public official, and that after the claim is paid by the surety expects to recoup its losses from the official. The bond amount, also called the penal sum, refers to the maximum amount that the surety will pay if the principal does not meet the obligations of the bond. Minimum bond amounts are set by statute and were recently increased. Insurance, on the other hand, is normally a 2-party contract that transfers the risk of loss from one party to another in exchange for payment. With insurance, the losses are usually not recoverable by the insurer. Blanket bonds and fidelity bonds are both terms that use the word bond in them, but usually refer to insurance. A blanket bond generally refers to an insurance policy covering multiple officials and employees. Under Tennessee law, when a blanket surety bond has been required, an insurance policy has been used. Tennessee law requires two kinds of blanket bonds. One is at the state level, covering most state officials and employees, and another for each county, covering those not already covered by individual surety bonds. A fidelity bond refers to a specific type of insurance policy designed to cover the risk of loss caused by dishonest acts of covered employees. So what's Tennessee's current law requiring individual surety bonds? In Tennessee, the surety bond process is regulated at every step of the way. The current law addresses which officials must have an individual surety bond, the coverage of the bond amounts, the process for the approval of the bond, who pays for the bond, and the consequences of not having that bond. The law requires that the forms for the official bonds be prescribed by the Comptroller of the Treasury with the approval of the Attorney General's office, and that the governmental entity pay for the cost of the surety bond. As shown in Table 4 and 5, the minimum amount of the bond is generally set by statute. This is only a minimum amount, and the local governments can require higher bond amounts. Bond amounts are set in a few different ways, such as revenue-based calculations, population-based, court determination, county legislative body, or presiding judge determination, and sometimes set at a specific amount. A quick correction to the table for the developmental district in the Human Resources Agency position. The amount of the bond is a revenue-based calculation and not a reasonable standard. That was recently changed this year. The price of a surety bond depends on several things, such as the bond amount required, the obligations covered in the bond, the internal controls that the local government uses, the relevant background of the individual being bonded, such as the financial status and credit history. To understand what a public official bond will cover, you have to look at the actual bond language, those statutes calling for that bond, any statutes governing the conduct or duty of the bonded official, and the relevant case law. Tennessee has a public official bond form provided by the Comptroller's Office on its website, and this is attached to the end of the memo on page 12. Within this form, certain language is required, is detailed in the statute, and this required bond form language is shown on page 6 of the report. This required language lists two main obligations. The first is faithful performance of official duties, and the second is to account for all money, property, and records. The first obligation of faithful performance is the most significant and provides broad coverage for either failing to take a required act or failing to refrain from doing something which by its nature should not have been done. These obligations, for example, could be breached by the official through dishonesty, negligence, or malfeasance. The duties that must be faithful performed are often found in the statutes for the specific positions that must be bonded. Case law also provides insight into what events or acts will be covered by the bond. The claims on surety bonds are rare and unexpected because of the strict screening process used. To have a claim, the governmental entity shows the loss, the surety investigates it, and if found to be valid, will pay the claim if the public official cannot, and then turn to the official for reimbursement. So how would insurance act as a substitute for these individual surety bonds? Senate Bill 624 is introduced would allow any governmental entity to purchase insurance instead of an individual surety bond to cover crimes and employee dishonesty and ensure the faithful performance by officials and their employees of their fiduciary duties and responsibilities. The minimum limit or amount for coverage will be set at $400,000 per occurrence. The bill states that a certificate of insurance would satisfy all requirements for the filing of the official bonds by the public officials. Because insurance has not been used for this specific type of risk management of individual public officials in Tennessee, at best only an estimate could be made right now on the cost of the initial premiums. Insurance agents and state officials interviewed have indicated that the initial premiums would be set high because there is no market experience with this particular type of product. The fiscal note on the bill indicated that insurance may increase tort liability, but also stated that there should be a recurring decrease in local government expenditures because the costs associated with insurance policies are deemed less expensive than the costs associated with insurance, with surety bonds, The fiscal note goes on to say that insurance policies may ultimately be less expensive, but insurance comes with coverage limits and deductibles. While there are similarities between insurance and bonds, there are also many differences. Bonds make the official individually accountable, insurance will not. A surety bond will not be issued until the individual has been investigated, and the price of the bond will depend on what the investigation reveals. In fact, the bonding company may refuse to issue a bond if they consider the risk too great. Insurance is written in favor of the insurance company with many exclusions and exemptions, while surety bonds are written in favor of the governmental entity is broadly defined in the law specifying the duties of the office covered. A table on page 9 of this memo compares the insurance to the surety bonds, and I'll quickly go over some of the differences. As already shown, the surety bond is a three-party contract. Insurance, on the other hand, is a two-party contract. With surety bonds, the losses are not expected and are ultimately recoverable from the public official, leaving that official with skin in the game. Insurance, on the other hand, these losses are expected and are not generally recoverable from the insured. A surety bond is a 2- or 3-page document written in favor of the state, while the insurance is often a multi-page document containing many exclusions and exceptions that is written in favor of the insurance company. The coverage amounts of the surety bonds in Tennessee varies depending on the position, with some positions requiring bonds well over $10 million. Senate Bill 624 proposes a minimum coverage amount of $400,000 per occurrence. The coverage provided by Tennessee's individual surety bond is very broad and covers an official's failure to act, negligence, and intentional conduct. In theory, insurance would cover everything a bond covers. Senate Bill 624 proposes allowing the optional use of a policy of insurance or an agreement with an administrative agency or pool that provides government crime coverage, employee dishonesty insurance, or equivalent coverage that ensures the faithful performance by officials and their employees of the fiduciary duties and responsibilities. Other states allow insurance to be used in lieu of surety bonds to cover public officials. Arkansas and Idaho are two examples of this. In the late 1980s, Arkansas set up a program called the Self-Insured Fidelity Bond Program. This program mandated a more limited form of coverage than the surety bond does in Tennessee. This mandatory program replaced and waived the previously required surety bonding of public officials and acts as an insurance policy covering losses caused by dishonesty for all government officials and employees in the state up to $250,000 per incident. It should be noted that the Arkansas system provides a more limited form of coverage than Tennessee's individual surety bond. And in Idaho, they set up a program to provide optional insurance coverage in lieu of surety bonds. They have one system at the state level covering all officials and employees that is similar to Tennessee's state-level blanket policy. They also have an optional program for counties and cities. Idaho's coverage on both the state and local levels is an insurance policy, and it provides broader coverage than the Arkansas system. More information on how other states use insurance in lieu of surety bonds will be provided in the draft in October. Thank you. Any questions?
Interesting area. Mayor Huffman.
What's the fiscal note on the bill?
You're asking the sponsor? Well, I'll yield to Mr. Shaver.
What would you like to know specifically?
What the fiscal note, I mean, I don't recall what the fiscal note on it was. The dollar amount.
They didn't give a specific dollar amount. It says, according to the Office of the Comptroller, this bill will not fiscally impact the agency. It says...
Really sounds like there isn't one.
Yeah, I think it's undeterminable at this time.
So we're going to present this again, did you say in October? The draft report in October. And it might be well to hear at that time from...
At this point, we don't have specific recommendations.
Yeah, from proponents, and I'd like to hear from somebody with, commerce insurance as well, I think. And some others who are in favor of the legislation, but we'll take that up in October. Any questions any other questions? Thank you very much. All right, then we're going to move to the main topic of the day as we continue our discussions about Public Chapter 441, the Acts of 2013 behind tab 4. We're working towards having our panel presentations today. Before that, as you'll see on your agenda, Ms. Eldridge is here, along with Mr. Terry, to talk about other states' laws. I hadn't been able to talk with Ms. Eldridge about this, but in anticipation of the meeting today, there's a lot of material here about the comparative data in states, and I've asked that we get a summary here so that we can get to our panelists. I know there are a number of elected officials that want to give their testimony and have time for questions, but have to return home to their districts and the like, their counties, and so we don't want to impede that, but it's important to sort of set the stage that we get the overview of what other states are doing, because that's relevant to some of the testimony we may hear today. So, Leah, if you could help us sort of, yeah, I know it's a tall order. There's a lot of material here, but let me recognize Senator Kyle here before we go.
Mr. Chairman, we may consider, since we are dealing with elected officials and those have some capacity for some technology of allowing officials to record or webcast their views and viewpoints without having to come here over the next several weeks or months, and then we could put a compilation together. I'm just saying that'd be possible, as opposed to asking people to leave their offices or leave their hometowns. But just an idea of a way to try to facilitate testimony by using this information, the technology that we have.
If I'm not mistaken, once we get through the municipal panel, if the county presenters and the municipal presenters today and tomorrow, do we have? That's the end of the panel. So don't leave. Well, now that you're here, please stay and give us your personal testimony. But point well taken. And again, for those who are here and tell folks back at home, we are now, video streaming these proceedings, and they are also archived for those who want to come back and see what there is. Senator Kyle.
I would just say, Mr. Chairman, that I know we have excellent panels with great proponents, but there may be those folks who have a view or viewpoint that need to be able to communicate that to the commission, and that's really more what I was thinking of over before we begin our deliberations, that we open ourselves up to other voices that may be there.
I see. Okay, I understand that. And on that point, we have received inquiries from a number of people who would like to submit testimony in writing, have reports that they would like to give. Some who have already been here, and we asked them to submit what they presented in writing, and they have done so. And there are others who would like to be heard. We can't entertain everybody in person, but they plan to submit their reports or testimony in writing as well. Having said that, I asked Lenice how much we have in the way of written submissions, and she indicates that there's quite a bit. I don't know quite how to quantify that, but I do want you to know that the written materials are available and will be copied and made available to you if you would like them to be. We're not going to make copies of everything and circulate them unless it's the will of the body that we do otherwise. But there are some reports in hand, and there are others to come. And I'll remind you of that again before we get to our subsequent sessions where we begin actually working on TACIR's recommendation. Okay? And if we get some by video, we can see if we can accommodate that as well. Thank you. Forgive me. Go ahead.
Well, thank you, Chairman and Commissioners. I'm going to be presenting the research that we've collected on other states' laws regarding annexation. These results are preliminary, and we're continuing to review and revise our information as we continue through the study. Public Chapter 441 directed the Commission to study Tennessee Code Annotated Title VI, Chapter 51, which governs changes in city boundaries, including annexation. In addition to Public Chapter 441, two bills sent to TACIR for study, Senate Bill 731 and House Bill 590, would require voter approval before an annexation could be finalized. The information on other states' annexation laws are in your materials beginning on page 3. We found that the majority of states require consent from voters or owners in the area to be annexed, and different states use different methods for getting consent from voters. Most states require voters to vote in an election, and most states require that only voters or owners in the territory to be annexed can vote in that election. A few states require voters from the annexing city to vote in the election, and a couple of states make this optional. 3 states require that the vote totals from the city and territory be counted together, and if a majority of those voting in the election approve the annexation, then the annexation goes forward. 4 states require that the vote counts of the territory and the city be counted separately, so if a majority of those in the city approve it and a majority of those in the territory approve it, then the annexation is finalized. Some states authorize city to get consent from voters in a petition or mail ballot rather than holding an election. A few states require cities to hold an election if enough voters petition for one, and yet other states authorize voters or owners to stop an annexation if enough protest. In some states, annexation is a multi-step process, and the annexation must be approved by a third party before the issue is submitted to voters. Depending on the state, an annexation may have to be approved by a state level or local level board, the county, or the courts before the issue is submitted to voters. Some states require a city to have a comprehensive plan in place outlining the areas that it intends to annex, and any annexation must be consistent with that plan. Many of the annexation by consent states authorize annexation without consent in limited circumstances. A number of states allow cities to annex areas of unincorporated territory that's completely surrounded by a city. This is known as a donut hole or island, and they can do this without the consent of voters or owners. Some states actually have language in their statutes that prevent cities from annexing territory if it would create one of these islands or donut holes. Other cities allow states to annex city-owned property, and 3 states allow cities to annex non-contiguous city-owned property. A number of states have annexation without consent or allow it in somewhat broader set of circumstances. These are outlined in your materials. I thought I would run through a few of them. One example is Nevada, which allows cities and counties with populations under 700,000 to annex up to 40 acres of subdivided land. In West Virginia, a city can annex without consent in its UGB if it has countywide zoning and it had adopted impact fees by 2009. Also in Texas, home rule cities are allowed to annex without consent if their charter provisions allow it. As a part of our study, we're going to try to determine if home rule cities in other states can deviate from the general annexation laws in their state. I know California does not allow their home rule cities to deviate from the general annexation laws in their state. Indiana and Nebraska have no limitations on a city's authority to annex without consent. 2 states, Mississippi and Virginia, require annexation to be approved by a court. In Mississippi, it's the Chancery Court. In Virginia, it's a panel of 3 circuit court judges. In 3 states, a third-party entity approves the annexation. In Ohio, it's the Board of County Commissioners. In Minnesota, it's a state-level board known as the Municipal Boundaries Adjustment Unit. And in New Mexico, annexations can be approved by a local-level arbitration board or a state-level city boundary commission. There are no annexation laws in 9 states. Most of these are New England or Mid-Atlantic states where there's little or no incorporated territory left. Or in the case of Hawaii, where there is no city government, it's just state and county level. All the information on the annexation methods in other states is in your materials beginning on page 3, as I pointed out earlier. I thought I'd briefly walk you through one state's provisions in the chart on page 3. Arkansas is on page 3, and it divides the state laws up into involuntary annexation provisions and voluntary annexation provisions. In Arkansas, you can see that islands can be annexed without consent. And in the voluntary annexation column, it shows that owners can petition to be annexed, and a city can also initiate annexation by an election. The other bills sent to TACIR for study addressed more specific annexation issues, and I'll briefly run through the results of our research into other state laws on these topics. The first of these is annexation notice. The chart including this information is on page 21. One bill sent to us for study, Senate Bill 1381, would require a notice be sent to property owners 90 days prior to a proposed annexation. Another bill, 590, House Bill 590, would require notice to also be sent 90 days in advance. And an amendment to this bill would extend the notice period to 180 days. Tennessee law currently requires that notice of annexation be published in a newspaper 7 days prior to a public hearing when annexing by ordinance. When annexing by referendum, notice must be mailed to the affected property owners 14 days prior to the public hearing. Notice must also be posted in public places and published in a newspaper. In our research into other state laws, we found that the minimum notice requirement for intent to annex ranges anywhere from 14 to 30 days. The notice requirement for public hearings range anywhere from 7 to 60, and the public notice requirement before an election runs anywhere from 7 to 60 days. Another issue we looked at is public hearings and public information hearings before annexation. The chart showing this information is on page 23. Senate Bill 1381 that was sent to us for study would require 3 information hearings in addition to a public hearing before a city could annex by ordinance. And an amendment to this bill would have decreased the number of public information meetings to 1. Current law requires one public hearing prior to an annexation by ordinance or referendum, and there is no requirement for public information hearings. In our research, we found only one state, North Carolina, requires a public information hearing and a public hearing before an annexation. With regards to public hearings, we found that 29 states require at least one public hearing, 4 require 2, and there are no states that require more than 2 public hearings. Plaintiff services is another issue we looked at. The chart showing this information is on page 25. Senate Bill 1054 was passed this session. There were 2 sections of it, Section 5 and 6, which were taken out of the bill, and we included the language from these sections in our study. These sections would have added some requirements to the plan of services. It would have required that the plan show the standards for delivering services to the territory that's being annexed, and also information on the financial ability of cities to provide services to the territory. In our research into other state laws, we found 24 states require a plan of services, and 15 of these require budget or financial information to be provided in the plan. Let's see. Annexation of agricultural land is the subject of another bill that was sent to us for study. Let's see. Senate Bill 1316 would require municipalities from annexing land within its urban growth boundary that's zoned for agricultural use until there's a change in use triggered by a request for a non-agricultural zoning designation or by sale of territory for a use other than agricultural purposes. Public Chapter 441 imposes a 13-month moratorium on cities annexing agricultural property on their own initiative. Prior to this moratorium, cities were allowed to annex agricultural land without limitation. On page 29, you'll find the chart showing limitations on annexation of ag land in other states. We found that 9 states limit the annexation of agricultural land. Idaho and Ohio actually allow owners of agricultural land to petition for de-annexation. As noted earlier, Public Chapter 441 directed TACIR to study Tennessee Code Annotated Title 6, Chapter 51, which governs changes in city boundaries. Chapter 51 includes not only the laws governing annexation, but also de-annexation, mutual adjustment of corporate boundaries, and city mergers. And I thought I would briefly run through our research on these topics. First is de-annexation. The chart of de-annexation law begins on page 31. In Tennessee, only cities have the authority to initiate de-annexation, not residents or property owners. A city can de-annex property if it's approved by 3/4 of voters in an election. A city can also de-annex on its own initiative, but if residents can't object to de-annexation by submitting a petition, then an election must be held and a majority of those voting must approve the de-annexation. We found that 14 states authorize both city and property owners to initiate de-annexation. 13 states authorize only property owners to initiate it. 10 authorize only cities to initiate it. And a majority of states require a referendum or other form of consent before finalizing a de-annexation. Next is mutual adjustment of boundaries. This chart begins on page 34. Cities with contiguous boundaries may adjust their boundaries by mutual agreement here in Tennessee. We found 10 states have laws authorizing municipalities to adjust their boundaries by agreement. Finally, there's merger of cities. This chart is on page 35. Here in Tennessee, 2 or more contiguous cities that are located in the same county are authorized to merge into one city. The merger must be approved by a majority of those voting in each city. We found that 38 states have laws authorizing merger of cities, and 35 of those require a referendum before the merger can be finalized. This is a brief summary of what we found about the annexation laws in other states. We're continuing to look at other aspects of annexation law, including strip or corridor annexation. And I would just like to take a minute to recognize the staff and thank them for all the hard work that they've done on this, especially Chris Aldridge, our legal intern, who we really couldn't have done it without him. He really helped tremendously. So thank you again for allowing me to speak before you. Can I answer any additional questions?
Mayor Bragg.
During the course of your investigation, and thank you, it's very well put together, even though it is complicated and difficult to understand. But during the investigation, did you realize that any other states were going through this type of restudy or anything at this same time?
Not at the same time. North Carolina did recently. I'm sure everyone's heard about that. They went from being an annexation without consent state to an annexation by consent state. So,
Charles.
Thank you, Mr. Chairman. On I'm going to go to page 35, 36, 37. When you're talking about referendum, and I think you said 35 states require referendum.
33.
33 of the 50 require referendum. Tennessee has checked that they require a referendum.
It's optional. They can choose to annex by referendum if they want to.
Okay. Okay. Thank you.
Senator Henry.
Thanks. Did you all happen to find out whether the League of Cities or NACO had a position on this topic?
You mean?
Could we do that?
I think it'd be well to do that. I don't believe it has been done,
No.
but we should.
Right.
We'll let the record reflect that we will do that. Senator McNally.
Thank you, Mr. Chairman. On the notice requirements, we seem to be at the low end of the notice requirements. Is that correct? 7 days versus, I think the minimum of other states is 14.
For notice to or intent to annex,
Okay.
yes.
And what about the requirement about mail notification? How many of the states require notification by mail?
Let's see. I don't think we counted. I can count them right now.
Oh, that's okay. You can get back to me. That's
But
fine.
it's in the chart.
Okay.
But
Mr. Vice Chairman.
I think those two areas are areas where we're at least out of balance with the majority of states.
yeah, it's definitely on the low end.
Thank you, Mr. Chairman. This is a heck of a report. A lot of detail, as Mayor Bragg said, a lot of in-depth research, and we appreciate that very much. I have a question. I was bumfuzzled until Mayor Huffman explained it to me, and we may have somebody like Senator Tracy who doesn't understand. But explain the island category, please. Senator Tracy said, I didn't know we had islands in Alabama and Arkansas, and but I got the answer.
Yeah. It's just a unincorporated territory that sits in the middle of the city. They refer to it as donut holes, I think, here in Tennessee. Other states call them islands. So,
Mayor Huffman.
Thank you, Mr. Chairman. On page 31, Leah, a city can de-annex property if it's approved by 3/4 of the voters in an election. Is that the voters in the entire city or voters just in the territory to be de-annexed?
I think it's just in the territory, but I'll go back and check just to make sure.
Thanks.
Yeah, I think it would be helpful too if we could have those summaries that you've given in your testimony for our notebooks. So
Okay.
it's sort of a cheat sheet. Look down and see how many states do this and how many states don't, and that sort of thing. But most states do allow the right to vote. Any other questions? Yes, sir, Mayor Bragg.
In Tennessee, the current law does require that you annex an island.
In Tennessee, don't think that it requires it. I think it's in a lot of other states that require annexation by consent. They do allow these cities to annex without consent these islands. So, I don't necessarily think it's required. It's just an option.
So you can have an island in Tennessee.
I think so. Yes.
I think that's correct. I think some of our presenters may touch on examples of that, because it creates some unique situations, if not problematic, yes. Other questions? Great job. Thank you, Leah. Thank you. Mr. Terry?
Thank you, Mr. Chairman.
Yes, sir. Good to see you.
Mr. Chairman, Director Patrick, members of the Commission, it is my pleasure to continue our long conversation about growth boundaries and Title VI, Chapter 58, Public Chapter 1101. I do want to emphasize what Leah said as well, that a lot of this is preliminary. There will be subsequent research, and some of it could change. We've talked about growth boundaries, and I thought, just what is a growth boundary? So there are different terms that are used across the country to refer to these growth boundaries. There are urban growth boundaries, there are urban growth areas, there are urban service boundaries, and there are spheres of influence. They all mean about the same thing, that the urban growth boundary is defined as a line around a municipality that separates urbanization from a more rural area. An urban services boundary denotes the edges of an urban service area, which is the line beyond which the city will not provide public services. So the sphere of influence is the same thing, and there are a couple of western states that have that. Growth boundaries are not necessarily a new item in this country either. The first growth boundary was adopted in Lexington, Kentucky in 1958 with the specific intent of protecting all the horse farms around Lexington. So the original intent of a growth boundary was to contain urban development within a defined area and prevent small sprawl type development. However, in most areas as well, the intent has been expanded to include definition of an area in which a city can expand and annex territory. So that's also embodied in growth boundaries. I want to refer you to the chart on page 38, and you will note that there are two columns there under other states' laws, one for urban growth boundaries and one for comprehensive planning. 5 states have mandatory urban growth boundaries. One of those states is Tennessee, of course. Our law is a little bit different from some of those, and I think it makes us a little bit unique in that regard. First, we have a coordinating committee in each county, and that develops the countywide growth plan with the relationship of cities and counties. All other states have their growth boundary tied into comprehensive planning and comprehensive plans and planning process that they go through with a planning commission. Some have state agencies that approve or disapprove of those plans, and they're based upon state goals and state policies. The second unique feature of our law is in the joint economic and community development boards. No other state has anything comparable to that I've been able to find. And other states do have a requirement in their comprehensive planning laws that one element has to be a concern on economic development or a section on economic development. Third, our law creates planned growth areas in counties outside of the cities. That's also a unique feature. The reason we might have planned growth areas is that it goes back to the annexation battles, as you recall, from the mid-1990s and the tiny towns laws, and that might have been invited in that planned growth area. There was also the need to take into account urban type development that might be located outside of a municipality and in the county. Fourth, the 15-year tax benefit that counties receive upon annexation of revenue-producing property. That's somewhat unique here. And as a side note on that, according to the Department of Revenue, 7 counties will lose some revenue next year in 2014 when that 15-year period runs out.
Have those, excuse me, Mr. Terry, have those counties been identified? Do we have that information?
Yes, sir.
In our materials here? Do we have?
I have it in my report here.
It'd be good for us to know.
It's available to us, yes.
Okay. Yes. Mayor Huffman.
Chairman, thank you. Does that include wholesale beer tax as well?
I think that's included in those taxes.
Not just
wholesale beer?
Right.
Well, wait a minute.
Or is it just sales tax?
I think that's just sales tax, because wholesale taxes are paid by the wholesalers.
Or wholesale beer tax, is that not in the 15-year? Could you check, Bill?
We'll get back on you. We've talked to the Department of Revenue, but some of us have forgotten that.
Bill, do you have those counties?
Yes.
Could you just, for the record, tell us what they are?
Blunt, Granger, Madison, Robertson, Sevier, Tipton, Washington.
A little more slowly, a little louder.
Blunt, Granger, Madison, Robertson, Sevier, Tipton, Washington. The total amount estimated for all those counties is something over $601,000.
All righty, thank you.
Now, back to our chart on page 38. The other states that have mandatory growth boundary laws are Maryland, Oregon, Washington, Hawaii. as noted, their growth boundary requirements are tied into their state requirements that all local governments have to have a comprehensive plan. Here again, Tennessee is a little bit different. Here, comprehensive planning is optional. It's permissive. But growth planning is not. It's mandatory. However, Chapter 58 of Title VI requires that all counties have a growth plan that incorporates urban growth boundaries, planned growth areas, and rural areas. There's no relationship between that and Title 13 planning. The effort to get planning into this chapter was a part of the law that says prior to proposing an urban growth boundary or a planned growth area, that certain planning reports, projections, and studies had to be completed. However, the section of law that directs the Local Government Planning Advisory Committee to approve a growth plan when all local governments have agreed to that growth plan appears to eliminate the planning requirements. And consequently, we have a lot of county growth plans that are planned growth area and urban growth boundary maps. Other states have optional growth boundary laws, not mandatory, and those are listed in your chart. And there are 14 of those, I believe. So that would seem to sum up the issue on growth boundaries, wouldn't you think? But no. There's an animal called home rule. And there are 30 home rule states. And then home rule might be defined as the ability of city and county governments to exercise discretion with respect to government form, structure, functions, fiscal, and regulatory matters. There's a great deal of variation in home rule powers across the country, strong home rule states and weak ones. But for example, Michigan is considered to be a strong home rule state, and so there 13 communities have created their own growth boundaries through their home rule powers. Other states, such as New Jersey and California, do the same thing. And I think I'm sure there are others, particularly in the mid-Atlantic area, where home rule powers are fairly strong in some of those states. So that covers growth boundaries. Let's talk a little bit about planning. It's your second column on
Mr. Terry, excuse me, I want to ask a question here because some of us, we realize that, for example, in Tennessee we have some home rule counties, for example.
Two.
Yeah, so where's Tennessee fit into your repertoire there? Is Tennessee a home rule state, or is it just a state that has two home rule counties?
I don't know which way you call it, but it has home rule counties and cities. There are 14 cities that have home rule charters in 2 counties.
And they all vary to some extent. Just because you're a home rule municipality doesn't mean that your charter reads the same as another home rule, correct?
And then there's also a provision that your home rule powers cannot transcend general state law. Can't override it.
Mayor Huffman.
Thank you, Mr. Chairman. I'm a little bit confused now, Bill, about the home rule and the growth boundary. If you're a home rule city, can you extend your planning and zoning authority beyond that city's UGB in a county if the county has zoning?
No, I think you've got to go through the standard procedures that are spelled out in the law on how you extend that.
And when you say the law, you mean the state law?
Tennessee law, yes. That would be under the Chapter 6 or Chapter 58 of Title 6 and under the zoning law in Title 13. Comprehensive planning, I noted, was mandatory in some states. 20-some-odd states have mandatory comprehensive planning. That means that the state mandates that a city and a county has to have a comprehensive plan, and that has to meet certain goals and objectives of the states that have that. The other states that are permissive, which are most of us, that it's just that. It's permissive planning. You may adopt a plan. You may do certain things with that. But in the mandatory plans, it's somewhat different. They have to have the plan. They have to meet requirements. And in some states that are permissive but have some quirks in their law, such as Georgia, It's permissive planning, but it's mandatory if the cities and counties want to maintain eligibility for state funding of different kinds. That same situation exists in Massachusetts. And another interesting thing, in Vermont, for example, if a city wants to adopt a zoning regulation, which they call bylaws, they have to have a comprehensive plan, even though planning is permissive in Vermont. In order to be brief, I'm not going into detail about what constitutes a comprehensive plan, but just say that there's a lot involved in it, and we'll write that up in part of their final report. In our law in Tennessee, planning is permissive. It's contained in Title 13, Chapters 3 and 4. It does state in that law that it is the function and duty of a planning commission to make and adopt an official general plan for the physical development of the municipality, including any area outside of the boundaries, which in the commission's judgment bears relation to the planning of the municipality. So we have mandatory growth boundaries, permissive growth boundaries, same thing on planning, mandatory and permissive all across the country. Now I want to refer you to page 41. It's where the other chart is. That page shows that what current law is on amending a growth plan. It also shows two bills that were referred to TACIR for study that have an effect on amending growth plans. First bill is Senate Bill 613, House Bill 1035, which provides a, so we say, a new method of revising growth plans. One part of it refers to the revision or the adoption of a growth boundary amendment. The other part refers to the provision of, to the revision of the entire growth plan, and the procedures are spelled out in that bill to do that. Under our current law, a city or a county may propose amendments to the growth boundary as often as they want to. And there are about, I think it's about 25 counties have revised their growth plans since the initial adoption of them, the expiration of that 3-year period where they were kind of frozen in time. The other bill.
Just one more, please. Yeah.
Yes.
Mayor Hubb.
Thank you, Mr. Chairman. Bill, let me ask you, under this bill, does the process remain the same where everyone's got to approve the change in the UGB? Every city?
If you want the LGPAC, Local Government Planning Advisory Committee, to automatically approve your growth plan, then yes, all the entities have to agree.
So not just City A, but if you've got other cities, City B, City C, all of them have to agree, as well as the county planning commission, excuse me, the county commission.
Yeah, because the growth boundary is an amendment to the growth plan.
So that part hasn't changed in this bill.
Now, what it would change is to revise the entire growth plan, and the bill has some fairly specific requirements on the revision of the growth plan itself and an amendment to a boundary, how that is accomplished.
Mayor Waters.
I notice it says here, it says under current law that a city or county may propose amendments and file notice with the county executive and the mayor of every city. Is there anything in the law that addresses, say someone sends you a letter and gives you a notice and you just don't do anything? You don't call the committee together.
Are you talking about calling the coordinating committee back together?
Yes.
Now, there's something in the law that says that you have to do that too, within a certain period of time.
And what if you don't?
You're in violation of the law.
Okay.
Now, what's the extent of that? Who knows? It's never...
You go to planning court.
Yeah. Whoever wanted you to convene that committee probably gets mad.
I'm sorry. Go ahead.
On page 41, where I'm talking now, the second bill that was sent to us was Senate Bill 732 and House Bill 231, which places restrictions on the ability of a mayor of a municipality that has not annexed all territory within its urban growth boundary to propose an amendment to the growth plan and to serve on the coordinating committee. Those are the two bills that were sent us dealing with revisions to the growth plan. The table itself, the chart, shows other states' requirements on amending comprehensive plans. And these are the mandatory states only. The permissive states can amend a plan anytime you want to. The mandatory states have a few more restrictions on that. For example, in Alaska, it's 2 to 5 years. California may be updated as necessary, but no more than 4 times a year. Connecticut, at least every 10 years. So there is an amendment process in other states as well. With that, I'll close, unless there are other questions.
Questions for Mr. Terry? Senator Henry, you're recognized.
Thanks, sir. Bill, does these two bills apply to counties with the metropolitan form of government either?
No, sir.
Sir?
No, sir.
Thank you.
Chairman Sargent.
Thank you, Mr. Chairman. Bill, can you tell me how many counties have planning commissions and planning and zoning in place?
I can't tell you right off the top of my head, but that information is available. It's roughly, there are 95 counties. I think about 75 or 70 have planning commissions, which would involve also adoption of subdivision regulations. And about, I think it's about 47 or 49 counties have zoning and the rest do not.
Okay. On our cities, how many of our cities have the same thing?
I can't tell you off the top of my head.
Would you say
that information is available? I think most.
Okay. If you could
the ones that would not would be the very small ones.
So only 47 to 49 have zoning in. What was your last statement? 47 to 49 had zoning and planning?
Yeah, counties. There are 47 to 49 counties, I think, that have planning and zoning.
Okay, thank you.
I'll get you the exact numbers on that.
Further questions for Mr. Terry? Thank you, Bill. Appreciate that very much. And now we're going to move into the panel presentation portion of our agenda. We have on behalf of county governments, a number of elected officials here today. You'll see in your materials that we have 6 presenters, and we have set the table so that you can either sit at the table and speak from the podium. You can sit at the table and speak from the table. We've been through this a couple of times, but if you feel comfortable to come forward, and I'll just for the record let our audience know that we will hear today from Shelby County Mayor Mark Luttrell, Williamson County Mayor Rogers Anderson, Fayette County Mayor Skip Taylor. We will also hear from the Tennessee County Commissioners Association. David Connor is here, the Executive Director. The Tennessee County Highway Officials Association, Rodney Carmichael, Executive Director. And from Washington County, Highway Superintendent John Deakins. Welcome to all of you. Thank you for being here. Thank you for your patience in getting on deck and at bat. And we will begin with Shelby County Mayor Mark Luttrell. Mayor Luttrell, if you'd feel free to go to the podium there. Yeah, that's great. So we have it sort of set up so we can have a panel discussion afterwards if need be. Mayor Luttrell, you're recognized. Welcome, and thank you for being here.
Well, thank you, Mr. Chairman, and certainly commissioners, fellow county mayors. It's indeed an honor and a pleasure for me to be with you this morning or this afternoon to really share some thoughts on this whole issue of annexation, urban growth boundaries, and such. I'll start off by saying that really my interest in this subject was really pricked within the last year, where we had a rather contentious annexation that took place in the city of Memphis. And as I watched the confusion, the consternation, and anxiety surrounding that event, I just thought there's got to be a better way. There's got to be a more harmonious way of meeting the needs of all concerned. And it was at that time that that I started giving some study to this. In the process of really preparing for this particular event today, I spent a great deal of time talking to, in Shelby County, we have 7 municipalities, and of course the county mayor. I took time to sit down with all of the mayors in Shelby County to discuss this issue with them. Spent a great deal of time talking to our planning division, talking to the planning divisions in the various municipalities. Reached out to my good friend and neighbor Jeff Huffman up in Tipton County to get his sage advice. And really, what became very apparent to me in all of these discussions, if there was one thing that people seem to agree on, it's that 1101, Chapter 1101, is solid legislation. I would ask some of the city mayors if they wanted to reopen the process, redraw the boundaries. They said, no, we don't want to do that. We think it's basically very good, solid legislation. But like any legislation that is 10, 11, 12 years old, there comes a time when you really start to look at it and see, well, how can we tighten it up? How can we improve it? And as I would talk to these people throughout the county about what they found good and what they found that could be improved, there were a number of little things that came up. And I realized then that really what I should be considering and addressing are those overarching issues that can have a profound impact that with some minor work could be improved. Certainly, I think to start off with, there seems to be a general consensus that annexation by referendum is preferred. And that's, I'll start off by saying that that's my position. I do think that being one of the few states that has not embraced annexation by referendum, that we're somewhat behind the 8 ball. That we could, I think, in large part, relieve a great deal of the anxiety that we see surrounding any annexation, and move forward with annexation by referendum. But as in all issues like that, there are a number of details that have to be addressed. But why is it important that we annex by referendum? First of all, our current program that we have it's involuntary, referred to often as involuntary annexation. I think we all would agree that one of the fundamental principles of our democracy is the right of popular determination. Certainly, owning land and possession of property, you should have a right, or should have a say in how laws, rules, and regulations are structured around the management of your property. We are only one of few states that do require or do have involuntary annexation. And the trend seems to be very progressively moving toward providing more public input, allowing the public to have a very significant role in that process. Our current process some serious questions about whether or not due process is followed. When decisions are being made and people who are affected by those decisions do not have input into the process, then certainly I think many consider that to be a flaw in the system. The current way of annexation runs contrary to our incorporation statute. In Tennessee, when you are incorporating into a community or a community is incorporating, the public has a right and a method for providing input into that process. Yet, when it comes to annexation, they do not have that input. I think certainly if we were to go to a referendum, then it would bring our annexation procedures more in line with our incorporation procedures. The process, although law does specify the procedures that should be followed in an annexation, our process now is inefficient. It's inefficient as it relates to the notification process, inconsistencies, interpretations of the law. In our particular case, in the South Cordova annexation that we experienced, that I referenced a while ago, there was a lot of finger pointing about whether or not certain standards of 1101 had been met. And that certainly created significantly to the confusion and consternation surrounding it. But 1101 is solid legislation, and certainly I am not proposing that we significantly change that. I'd like to just really focus on two things that I would like for you to consider as we move through this process of the review of Chapter 1101. One is the infrastructure investment. Under the current guidelines for the urban growth planning, with the annexation areas being defined, many municipalities will at that time start making capital investments in that reserve area. Under a referendum procedure, should a referendum work against the investing community, then there's a question there of how does that community recoup its investment. If they've made a capital investment in infrastructure, the sewer, the water in so many areas, and the referendum works against them, then how do we address that investment that's been made in an equitable way? Certainly that's one of the details that should be addressed and worked out. Another concern is what's referred to as the extraterritorial jurisdiction. And in Shelby County, we have some unique private acts that address the extraterritorial jurisdiction questions. But certainly in other areas of our state, there are other extraterritorial issues that should be addressed in the context of 1101. In our particular case, it has to do with moving outside your urban growth boundaries and allowing for zoning decisions to be made, which can complicate issues moving down the road. We just recently, in the last year, had a situation of where under the private acts, there was some planning that was done, some zoning decisions that were made in areas outside of the other urban growth area by the Shelby County and Memphis and Shelby County planning divisions. But how do we address those extraterritorial issues that really can create some real consternation as we move forward in this area? Those are two concerns that we have in our local area that can have some application to other areas of the state, and certainly I think with some minor revisions and adjustments to some of the language in 1101, our concerns can be addressed. Mr. Chairman, I appreciate this opportunity. Certainly look forward to working with the Commission as we continue to move through this process. I welcome questions that you might have regarding things that have been mentioned, certainly any recommendations that you all might have. Thank you.
Thank you very much, Mayor Luttrell. If there are any immediate questions, we'll entertain them, or if you'd like to wait until our presenters speak, then that may conjure up some other thoughts and questions they have if they're not at the moment. So, Mayor Luttrell, thank you so much. If you just rejoin our group here, and we'll then hear from our next presenter, Rogers Anderson. Feel like you're back here for TACIR. Welcome back, Mayor. Good to have you. It's like old home week, right?
Thank you. Thank you, Mr. Chairman.
Yes, sir.
As I begin my remarks, I'm not quite as fluent as the Shelby County Mayor, so I write everything down. And I appreciate his ability to do that. In dealing with this, I also want to recognize that my state representative here, so he can't hold everything against me I say today, and Charles Sargent. We also have with me today the mayor of Brentwood, who is sitting behind me, and the Best Highway Commission chairman that a man would want, and that's Eddie Hood that is here. I've broken this down into 3 parts. If you'll bear with me, I'll go through it. Overall, Public Chapter 1101 has lent a great deal of predictability to annexation in the incorporated county, such as is seen in the improvements over the past practices. As the municipalities has found designated what the future boundaries might be, the decision makers in the unincorporated county can now make informed choices as to what future land use and public infrastructure decisions. Moreover, it has been provided for the framework for closer cooperation with our municipality, and I must say that in Williamson County and our 6 cities, we get along. Bullet number 2 says, however, the Public Chapter 1101 does have a number of flaws. It is both cumbersome to adopt and to amend. For an example, in order for Williamson County to adopt its growth plan or amend it in the future, a total of 16 public meetings are mandatory. 2 for the county, and 2 each for the 6 municipalities, and 2 for the coordinating committee. While this finding is particular in Williamson County circumstances, a variation of this exists statewide in all of the areas. Moreover, while this demonstrates a great deal of transparency, it arguably has furthered a reluctance to amend the growth boundaries that will likely become more and more apparent in the coming years as these plans age. This time, effort and expense of reconstituting the steering committee, developing the proposals, taking those proposals to the county municipality entities charged with their review, adoption, and returning back to the coordinating committee for final adoption is likely to influence communities to keep the existing growth plans in place. Such is counterintuitive to the basic nature of planning, the ability to respond to changing conditions in a prompt manner. Public Chapter 1101 fails to identify a uniform process to establish the reasonableness of the areas devoted to growth boundaries. One of the bills under consideration, Senate Bill 732 and House Bill 231 by TACIR, speaks indirectly to this in that it seeks to restrict the ability for a municipality to add to their urban growth boundaries via amendment until all of the area within their UGB has been annexed. It has been our experience that several UGBs within Williamson County are quite sizable when considering projected growth and the area necessary to accommodate that projected growth. However, due to the changing conditions, the size of the availability area is not so important as to where the growth is being directed by the market forces. In such cases, the UGBs are arguably so large as to make the standard put forth under Senate Bill 732 and House Bill 231 unobtainable. Again, was the amendment process more flexible, or the need for such a proposal may not exist? Public Chapter 1101 failed to identify means for cost sharing. Currently, it is up to the respective counties to initiate the process, bear the cost of legal ads, and other related expenses. In the case of Williamson County, the cost of coordinating the mapping services, related printing costs were solely borne by the county. Logistically, this made a great deal of sense, but practically we lacked a legal method to suballocate these costs out. Some form of per capita sharing is more alternative that should be considered. Next bullet. Closely tied to the reasonable issue is that of the population projections. Under Public Chapter 1101, such provisions shall be developed in conjunction with the University of Tennessee, Tennessee Annexate 658-106A2. As it turns out, the population projections were something, take it or leave it, proposition at that time. The importance of the population projections were that they are arguably the most important factor in determining future land needs, thus driving the entire process. Sources other than the University of Tennessee should be considered for inclusion as a source for these projections. There are several miscellaneous provisions within the Public Chapter 1101 that might be worth additional scrutiny. These would include more clarity as to the meaning and or the intent of certain terms, high density, low density. 2, more clarity on the role of the rural areas within the overall Public Chapter 1101. And 3, a procedure how to take into account the reasonableness of growth boundaries within a municipality split by county lines. Some specific comments on the bills that are under study. Senate Bill 1316, and these are my opinions. House Bill 1249 would prohibit the annexation of land within an urban growth and boundary zone for agricultural use until there is a change in use triggered by a request for non-agricultural zoning designation or by sale of the territory for use other than agricultural purposes. This is something of a two-pronged test. In the case of the unincorporated Williamson County, all properties are zoned to allow agricultural uses. Moreover, our county would not entertain the request for non-agricultural zoning that would occur as a part of the subsequent annexation. Finally, the criteria for the sale of the territory for use other than agricultural purposes introduces a degree of vagueness and subtlety that are at odds with good practice and transparency enforcement of this provision. Senate Bill 1381 and House Bill 1319 would require notice to be mailed 90 days in advance to owners of property under consideration for annexation, and that a minimum of 3 informational meetings be held. While the transparency offered by this proposed process is laudable, I would caution that the length of a notice period and the number of informational meetings would seem excessive, particularly in the cases of small friendly annexations. Further, given that these annexations are subject to public hearings at both the Planning Commission and the City Commission levels, the 3 informational meetings should be considered for reduction. Senate Bill 613 and House Bill 1035 revises the procedure for amending growth plans. Once the coordinating committee is reconvened, each entity is limited to 1 amendment. No additional amendments may be considered by the coordinating committee until the overall amendment process is completed. While this approach might result in thoughtful, incremental amendments to growth plans, this should not be considered without first taking into account the cumbersome nature of the amendment process that it currently exists on file. Senate Bill 732, House Bill 231 was discussed earlier in the context of this reasonable of the growth boundaries. This legislation would place restrictions on the ability of a municipality to amend the growth plan until all areas within the existing growth plan had been annexed. In addition to the above comments, it would be added that given the collaborative nature of the establishment of any growth boundaries, it would seem that the local coordinating committee would be the appropriate body to determine whether a given request to expand one's growth boundary is reasonable. Senate Bill 731, House Bill 230, and Senate Bill 869 and House Bill 590 require that future annexations under the UGBs occur via referendum, with the former only requiring such on growth plans as they might be amended in the future. Part of the original rationale for Public Chapter 1101 was to provide notice when a given municipality might expand in the future. Perhaps the previous criticism, cumbersome process for adopting and amending a countywide growth plan has the sidebar benefit that the number of required meetings would make it difficult to argue that a given annexation was a surprise to the residents in the area. If Senate Bill 869 and House Bill 590 are adopted, they would effectively end the practice of annexation by ordinances. Final comments. Public Chapter 1101 can be characterized as any number of public chapters can be, while a number of flaws should be considered. It is a basic framework in which virtually all the counties of Tennessee must operate. Even minor amendments could result in a series of cascading effects that might be worse than the problems that the amendments are intended to solve. A series of questions should be considered in the context. 1. Are the problems these bills intended to annex representation to statewide concerns, or are they intended to address concerns about local in nature? Given the common thread and seemingly reluctance to accept annexation by ordinance is appropriate, is there a sentiment that all annexations should be accomplished by referendum? 3, is there a statewide concern that transparency through the Public Chapter 1101 is lacking, or is there just an issue more local in nature? 4, finally, given the age of most growth plans, it is possible that many of these perceived problems are a product of the fact that a number of plans, including our own, have been on the books for many years, and successive landowners may just now be learning of how these plans may affect the safe enjoyment of their properties. Mr. Chairman, I went through that hurriedly, but we tried to give it some serious thought. We're the fastest growing county in the state of Tennessee, but our unincorporated area is one of the slowest. In the last 10 years census, we had less than 100 people in the unincorporated area addition taken out for annexation. So we're doing something right with our cities, and we're proud of it. I'll entertain questions. Thank you.
Thank you for that. Are there questions for the mayor? Mayor?
Thank you, Mr. Chairman. Rogers, I'm trying to determine, do you agree with Mayor Luttrell? Are you for a referendum, or are you opposed to referendum?
The way that we've got it set up here, I'm fine with the way it is. I respect the mayor's comments, but I don't necessarily concur with that.
Mayor, do you feel as though we're coming up on, I think, 15 years into the 20-year growth planning process? Do you feel like the plan that has been in place in your county is current, is up to date, or from your testimony I sense the little bit of frustration that it's not easy to amend, it's too cumbersome?
We've never been able to get back, Mr. Chairman. We've not had that request. What we found in those early days, and I was around during those period of times along with Charles and many others, and that we were afraid that we were not going to come back to the table. That occurred, so we took a larger bite than we probably really needed to. Since that time, we've had very little arguments with our cities. We've been able to work through our issues. We've gone through different mayors and county executives, different councilmen and different county commissioners. But I really do believe the secret to anything we do is, one, is communications with all of our elected officials. We're not going to agree 100%. And I just think it works in our county. And I'm proud to be down there.
Thank you, sir. Any other questions at this time? Mayor Waters.
Rogers, would you elaborate a little bit on the referendum issue? I mean, you said leave it the way it is. Tell us a little bit about the reasoning behind leaving it the way it is, as you see it.
Well, I think, Larry, I think all of us want transparency. We want to get the message out. It's also a costly endeavor to when you go through these public meetings like we do, we are getting that message. I know you're doing it, we're doing it. Annexation, in the way that it's set up currently, seems to be working for us. The referendum side, I'm speaking more the way it is and not what everyone's wanted to go to, Larry. I guess that's the best way to answer it. And I'm a little different, but it works in our county, and that's who I have to represent.
Well, it seems, Mayor, it seems to me that if you have the requisite transparency and it's working in your county, those are the kinds of things that generally engender support for annexation. I mean, I don't think what you're describing is necessarily inconsistent. In fact, it sounds like it might be very compatible with annexation by referendum, because sounds as though you've got the welcome mat out for folks, and that because there's communication and because there's transparency, it is working as it is. It's not to suggest, I would think, that it wouldn't work just as well if you had annexation by referendum. You see what I'm saying?
I do.
Yeah. County of good abode and all that sort of thing.
I understand that.
Yeah. Okay. Well, thank you. Yeah. Oh, Mr. Chairman.
I have to say it since my county mayor and good friend is here, but we look at it maybe a little differently. Then I know there's a lot of local fights, and I think they should be handled locally. And I'm going to use, Mayor Anderson, you can correct me if I'm wrong, but from 1990 to our census in 2010, we have grown over 100,000. We have some of the fastest growing cities, and in a county that has the fastest growing and it's working, I don't see where, and I know we have problems in different areas that we can probably solve, but when we're looking at that and it works, why don't other counties maybe look to see why it works in Williamson County instead of trying to mess everything up? I mean, and I'm looking at it strictly from a standpoint of, I know it's worked. sat on the County Planning Commission for 7 years, and I'm not saying everything's perfect, but overall, this has been, 1101 has worked extremely well as far as that's concerned. And, you know, to critique it and to tweak it a little bit, you know, I'm all in favor of, but why throw everything out of whack when the economic engine for Middle Tennessee, you almost could say for the state of Tennessee, is Williamson County? I mean, you know, corporations from it doesn't matter, from corporations to schools to the planning of our cities, you know, they're always rated one of the top. And why does it work there and doesn't work in other places is beyond me, and why everyone wants to fight all the time about something. So the only thing I'm saying, I congratulate the mayor for the job he's done. I have my Brentwood mayor out there. My Franklin mayor is not out there, but we've all talked about this, and they prefer, you know, unless, you know, not to drastically change 1101, because it's a very well document that was done 15 years ago, 14 years ago. Thank you. Thank you, Mayor.
Thank you, Mr. Chairman. Unfortunately, nothing drastic has been proposed yet, but this is why we have the forum for discussion about all things to be considered. Now, thank you. If there's nothing further, thank you, Mayor. We're on our list, we're supposed to take up Mayor Taylor, and I haven't been able to whisper in his ear, but we have a request by Mr. Carmichael, who I understand has a sort of a pressing conflict at this point. We have run a little bit long. We'd like to be able to accommodate you and hear from you next. Do you have any objection to that, Mayor Taylor? Thank you. Mr. Carmichael, you are recognized. I know you've got a video or other visual presentation. Rodney Carmichael, you are recognized. Welcome.
Good afternoon, Mr. Chairman. I am Rodney Carmichael, Executive Director of the Tennessee County Highway Officials Association. Joining me today is from Williamson County is Highway Superintendent Eddie Hood, who's also President of TCHOA, also Mr. Van Beauchers, who's the Murray County Road Superintendent, and of course Mr. Johnny Deakins, who's part of the panel. TCHOA is a statewide organization created to represent the interests of the 95 elected and appointed administrators of the County Highway Department, who are commonly referred to as County Highway Superintendents, Road Superintendents, Public Works Directors, or County Engineers. The transportation infrastructure, roads and bridges of any unit of local government is not only a tremendous asset, but also creates an overwhelming financial responsibility and liability. The 95 county highway officials in Tennessee are responsible for maintaining approximately 57,000 miles of roads and bridges, approximately 2,300 bridges, over 20 feet in length. That number of bridges does not include structures below 20 feet, which are totally unidentifiable. Municipalities are responsible for approximately 18,000 miles of streets, approximately 2,000 bridges, over 20 feet in length. Together, local governments own and maintain 84% of the roads, streets in Tennessee and 58% of the bridges. Constructing and maintaining that huge number of miles of roads, streets, and bridges is a tremendous financial burden that falls on the local governments. In today's market, repaving 1 mile of a county road 20 feet wide with 2 inches of asphalt costs approximately $100,000. In my previous life as a public service provider, I served on Public Chapter 1101 Implementation Steering Committee in 1998. Public Chapter 1101 has served the citizens of Tennessee very well, but it is time for a comprehensive review of the Act. County highway officials are not concerned with how annexation is achieved, ordinance or referendum. Our major concern is how municipalities' boundaries are established with the annexation. There is currently, as in the past, a tremendous tendency by municipalities to exclude the transportation infrastructure during the process of establishing annexation boundaries. Two of the main objectives of Public Chapter 1101 was to prevent strip annexation and to establish congruency in future annexations. In our opinion, these two objectives have fallen short. Mr. Chairman, I would like to give the Commission 5 examples of annexation and de-annexation that we believe have not followed the standard intent of Public Chapter 1101. and should be addressed in a comprehensive act of the review of the act. With your permission, Mr. Chairman, these examples were identified by county only, and identification of municipality has no purpose. So the first one I want to show you is on your screen. It's Robertson County. There's approximately 3.6 miles of road in Robertson County that the city wants to de-annex. As you can see, it's probably a pretty good structure for some of my rural counties, but not in particular in Robertson County. That street was annexed, County Road was annexed probably 20 years ago. To bring that street up to specs, to meet the county standards, will cost $500,000. So the city is going to try to de-annex it, and the county won't take it because they'll violate their own standards if they do. So I guess the courts will decide. In this particular slide, a municipality annexed the right-of-way of I-40, which includes 2 bridges, the underlying county roads. Later, by ordinance, the municipality de-annexed 4 roads and returned those roads to the Sevier County Highway Department for maintenance. In the de-annexing ordinance, the municipality retained I-40, the median, the travel lanes on both sides of the median, and the remainder of I-40 right-of-way inside the TDOT maintenance fence. Now, those are the bridges on I-40. There's one of the roads they de-annexed. Of course, the main road going underneath the bridges was de-annexed. There's one road. There's a second road that was de-annexed. And here's the plan of de-annexation, and you can see that only the road surface of I-40 retains. The next slide is from Hawkins County. A municipality annexed up to the bridge, skipped over the structure, continued with an annexation process on the other side of the bridge. The bridge has been condemned and is in the process of being replaced by Hawkins County. The replacement structure is 500 feet in length. Construction cost is $7.2 million. Less than a month ago, the state ordered the bridge closed to through traffic. The county spent $28,600 to make temporary repairs to reopen the bridge. In 2005, the Highway Department made applications for an 80-20 federal matching grant. The new structure is planned to open in May of 2014. And you can see that in this area, this is part of the old structure. The land you see down at the bottom is actually a city park. This is actually the surface of the old bridge. The new structure is to your left. Here's the annexation map. Okay, another example. It's in Franklin County. A small municipality in Franklin County annexed 1 foot of this bridge. Now, the cones you see there are about 3 feet, but the truth of the matter is I was on that bridge and traffic was pretty heavy and I got off. So it's kind of a narrow bridge. The reason they annexed this 1 foot of this bridge was to get to a retail establishment on the other side of the bridge. All right, this is the county road on one side of that establishment, and this is the county road on the other side. So they went 1 foot of a bridge, went across, picked up this private enterprise, and went around. Now, this is the de-annexation plan here. You see in the yellow, and of course you see the other point down there in the bottom right-hand side is also the yellow, which is part of the annexation.
Rodney, have any of these counties that you've described considered asking for low-interest loans from Williamson County?
We've approached the mayor on that several times. His road superintendent contends if he's going to loan money, he's going to loan it to the Highway Department in Williamson County. I have one more, Mr. Chairman. This is Murray County. You'll see a vehicle sitting there. The city annexed all the way down to the front of that vehicle right there. On both sides of the road, skipped over there, went across and picked up the left-hand side off and took the right-hand side, went about 2.5 miles on the right-hand side of the road, went on down. This is the same area. On the left-hand side is a railroad track, a big ditch, and Saturn. So there's nothing on the left-hand side. So the county owns the road, and the reason that was done, there was 600 future home sites there. And when the bubble burst on the housing industry, that kind of went by the wayside. So the de-annexation on the right-hand side ends here, 2.5 miles later. But the county still owns the road by the referendum, or it was actually by ordinance at that time. So, you know, we support a comprehensive review of Public Chapter 1101. Hopefully, when you do a comprehensive review, you can do some adjusting to the process. Maintaining roads and bridges in Tennessee is a very expensive process, and we need those infrastructure units, but we also need to be able to maintain them properly, and that's probably what we're not doing right now, both cities and counties, because of the funding mechanism. But these are issues that my group deal with every day. So we skip here, we skip there, we move our tractors from here to there to mow the right-of-way. So if you decide to do comprehensive annexation, those are some issues we'd like you to address.
Mr. Carmichael, are these, I'm assuming that the annexations you've described in each of those counties are within the urban growth boundaries of the respective municipalities.
Yes.
But the footprints that those create are what led to some of the legislation underlying the review that we're going through now. I know Representative Carter had questions about whether areas can expand their urban growth boundaries when they haven't filled the urban growth boundary that they had. And one way that they take advantage of the urban growth boundary without filling it is through these sort of strip concoctions that you've described. So it's on radar.
In 1998, when the act was passed, I was under the impression, I was on that steering committee, that those issues had been addressed in that comprehensive legislation about strip annexation and congruency in establishing boundaries. And somewhere along the line that got dropped out, but it needs to be reinserted. Thank you.
Thank you very much. We have a question or two here, Vice Chair.
Yeah, thank you, Mr. Chairman. Mr. Carmichael, good report. Thank you very much for that. Very in-depth. I just wonder about when you showed the street half in and half out, does your emergency communications district not become involved when things like this take place?
Well, you would think so, but I really can't address that. I mean, that's a large populated school right there. School buses use that route going in and out every day. So I would assume there are some overlapping of services, but it's so close to the school, I think everybody's going to respond no matter whose jurisdiction it might be.
Right. I know it's difficult when you don't know if you're in the city or the county and you live on the same street and
Yes,
your neighbor's waving to you.
Yes, sir.
Thank you, Mr. Chairman.
All right, sir. Thank you
very much.
Appreciate it. Mayor Taylor from Fayette County here. West Tennessee's well represented today. Pleased to have you.
Thank you, Mr. Chairman, members of the committee. I think the reason I'm up here is because Fayette County has been involved in almost every legislative action associated with growth, all the way back to the 1990s. So what we've got, what I want to show you today is some of the history on Fayette County, our growth, and sort of how that has affected we're a microcosm of what's going on, and then some of my comments on parcels legislation. For those of you not fully aware of Fayette County is, we're right next door to Shelby County, next door to Mayor Luttrell down there, and we've had issues with growth primarily coming out of Shelby County for a number of years. Back during the 90s when things started growing in Fayette County, we had issues with folks moving out from Shelby County and Memphis into Fayette County. We started having a bubble out there as far as growth on our western side. As you can see over here on the red, right next door, we had a lot of growth, particularly in what we call the Hickory-Wythe area, down south in Piperton, right across from Carrierville. Pre-1990, Fayette County had growth, had zoning, and also a planning commission. So we thought we were very progressive. We were trying to take care of our county. We were trying to be farsighted enough to be that county, rural county, was trying to take care of its people and knew what was going to go on. From 90 to 2000 was when our growth really started. We had numerous, unincorporated Fayette County started to have numerous subdivisions, particularly on the western side of the county, and had a migration out of Shelby County, primarily Memphis, into Fayette County. The town of Oakland started to grow at that time. They had a very change in administration, and they started having a very aggressive growth policy. And they did a number of annexations on their own during that period of time. From 2000 to 2008, of course, everybody in the state had a bubble. And we were probably one of the leaders as far as percentage-wise. Now, I can't compare to Williamson County and Rutherford County in number of people, but our percentage growth was up there with, and we're in the top 100 in the nation for many years. So from our perspective, we were having issues down there with a large percentage of folks moving into the county. And then and also we had Piperton in the south part of the county, which had been incorporated in the late 70s, I believe, actually started to grow some. For a number of years, there were just a couple hundred folks down there, just on the edge of Fayette County. At that time, you started having folks coming out from Collierville and Germantown area into Fayette County, and that city started to grow also. 2008 to now, of course, when Fayette County's bubble burst, it burst big. One of the biggest employers in the county, of course, was the housing industry. So things started slowing down quite a bit at that time, and we're still growing, but right now it's not near as much as it was. It's a little hard to read up on the screen, but basically what I'm talking about here is the Tiny Town Law. When Tiny Town was adopted in 1997, we had one city that took advantage of it. It was the town of Hickory With. Now, I know there are many across the state that took advantage of it, but in Fayette County, Hickory With automatically went from a very small crossroads in Fayette County with a grocery store, church, and a small gym to the largest town in Fayette County and probably one of the largest area-wise in the state of Tennessee. Went right down the line of Fayette County and Shelby County. And to be truthful, the reason that was there was the fear of people being annexed by the city of Memphis, because at that time a city could come across the county line and annexed. We do have one small town in Hardeman County that came across, Grand Junction, a little small town, great little place. They came across Fayette County, got 12 folks and a grocery store and the beer tax. So there was some history there that could happen, and of course we did have legislators in the Senate and representatives that were working on our behalf to try to stem that, and that's where we saw Tiny Town come from. In 2003, I believe, town of Oakland was successful in suing Hickory With. Hickory With went out of existence after the law was declared unconstitutional, and Fayette County was given the privilege of giving 3 years back of property taxes to all those landowners. Growth Plan 1101, Fayette County, as you're aware, if you've been studying this, is the only county to go through the full process of all the judges and mediation, arbitration, and having a judge tell you where your lines are. And we spent enough money to know it's there. We spent several $100,000 with everybody's included. And we're not anxious to open the process up, but we have areas that we need to address. And one is we're right on the edge of the mega site, and to open that up, we've got, because the area of Fayette County, I've got numerous cities that would like, when the process is opened up, make their bid for whatever they've got going. We have one need, I'm going to have many requests. I have no doubt about that. Just a few comments on what the laws that I think I was asked to sort of give some small comments on. Agricultural land annexation proposes to stop annexation of agricultural land to the city unless a land designation changes or is about to change. In Fayette County, our zoning is, our lowest zoning in the county is R1. That includes everything that does not have a higher zoning. You can do a single family house or agricultural property. You can have agricultural property in R2, R3, even industrial property, and it can be agricultural, but it be zoned otherwise. So while I think this is a valid attempt of making sure that land that is never going to change, that you're just being brought in for the tax base as opposed for any real use, I would encourage you to make that a little bit more specific so that it addresses county like Fayette County. Annexation notices, I think I agree with one of the previous speakers that I think it's a valid attempt of having prior notice to everybody, because I've got a couple of towns that have made noises they would like to annex some. And I have a lot of citizens that say they don't really want to be annexed. They need to be notified. Everybody needs to be notified, not only the ones who are going to be annexed, but maybe their neighbors also, because they have a stake in it to a certain extent. 3 months, basically 90 days out, and 3 notices is going to be overkill in my opinion, but they do need to have very much adequate notice, and they need to be involved in the process also. Amending the growth plan, I propose to allow only 1 amendment at a time to be considered by the coordinating committee. I can tell you when I went through the coordinating committee, it was as much about politics as it was about growth planning. And if you put only 1 issue on the table, I guarantee you there are 5 out in the hall waiting to come in. And if you don't address all of them at the same time, you're sort of at a stalemate. You need to have, I agree that if you have 1 in front of you, you're supposed, technically, theoretically, you should be able to give your full attention to it, make the best best decision on that and move forward. But in the real world, that's really not how it happens. Required for annexation, referendum required for annexation. And I know that's a hot topic, and I think everybody who's going to be annexed ought to have a say-so where they go into a city. Now, I'll say that and leave it to y'all's discretion how to go about that. Whether it is a full-fledged vote with an election commission and you take a vote and it's official, whether you do it similar now when you go outside the UGB where every parcel votes to whether to come in, whether it's some combination of the two, those are issues I think there are many schemes that could be adopted. I think you've seen a number of them across the U.S. who might be looked at and some combination of them. But I would like to let you know that because we're growing and we have some areas some cities that would like to grow, I have some companies that would like to come in to areas that are right on the edge, or maybe just slightly outside the edge of a city, who needs utilities. And there's very few utilities that are going to extend those into an area they do not control in some form or fashion. However you draft the law, whatever your recommendation is to the legislature, if you could incorporate that suggestion and how to deal with that, it would be much appreciated. I know there's a number of counties that are recruiting heavily on jobs. When you see a job, any sort of jobs comes into the state of Tennessee, I'll guarantee you the county's been involved in it, and they're recruiting just heavily. For every one you come in, there's probably 5 or 6 that lost out on it. So everybody's working hard to get them into the county, and that is one thing we need to be able to offer them, the utilities, when we find that piece of property that everybody agrees they should be at. Fully used growth plan area to growth plan changes. If you have to have all of your UGB used up prior to being able to participate in a coordinating committee, then you're not going to have anybody at that table but the people who have absolutely no UGB at all. And a lot of times those folks need to be involved in the discussion at the coordinating committee. You can get a lot of, like I said before, it's a lot about politics. If the coordinating committee can work out the politics when it goes back to the legislature, various bodies to be voted on, those can be taken care of. In Fayette County, though, I will say that we have a number of cities that have extremely large UGBs. When it went to the judges, it was really easy for them to make circles and send it back to us and let us live with it. But then there are very few cities in Fayette County that in 20, 30, even 50 years are going to fill up their UGBs. So there needs to be, I would very much like to see them shrunk down because that would cause me fewer headaches and I don't think cause them any problems. But just keep in mind this may be a double-edged sword. And of course, my contact information. Mr. Chairman, thank you for the opportunity to speak to you. I think my hat's off to you for taking on this issue. I was been working with this. I was on the commission prior to being county mayor. We were working with it then. This isn't something new. I realize this. This has been going on since the mid-90s, and here we are nearly 20 years later, and we're still talking about it. I'm hoping we're got it close to right, but I know we're always tweaking it. Thank you, Mr. Chairman.
Thank you, Mayor Taylor. Any questions at this time? Yeah, that was a infamous town and county, right? Good to have you. Thank you so much. All right, our next panelist then is from the County Commissioners Association, known to almost all of us, our Executive Director, David Connor. Welcome.
Good afternoon. David Conner with the County Commissioners Association. I'm thankful to be able to be here and address you on this issue. I'm going to kind of maybe just sum up a little bit of where some of our different perspectives have come from and talk about things. We still have Mr. Deakins here from Washington County to talk about some of their specific issues. City and county governments are both local governments, but in some ways they're very drastically different entities. Municipalities, to a degree, create themselves. People in a certain concentrated area decide we're going to incorporate. Maybe it's been done long ago. Maybe the legislature incorporated them. Maybe they had an election, but they decide we are going to organize as a municipality to provide either certain services our county doesn't provide, or we're going to provide a higher level of services. We've had some of the most recent, we've had cities created as recently as I think 1997, right before the passage of this act. Counties, on the other hand, are kind of a default level of government. Some of our counties in Tennessee have been here longer than Tennessee has. They go back to the days when this was the Western Territory of North Carolina. And I think our latest created counties were like 1879, something like that. So we've had 95 counties in Tennessee for a long time. Everybody in Tennessee lives in a county or else in a metropolitan consolidated form of government. So that county is there and is responsible for providing services to the citizens, basic fundamental services, a level of law enforcement, corrections, the court system, education system, highway and transportation, and basic infrastructure needs. And we're going to do that to everybody, whether you live inside city limits or outside city limits. We're not like some states where once you've moved into a city or been annexed by a city, you're no longer part of the county. I mean, I think in North Carolina, the incorporated areas are the jurisdiction of the cities, and the unincorporated areas are the jurisdiction of the counties. The county serves both municipal and residents of unincorporated areas. So how are we affected by annexation? Well, it really impacts us in a couple of different ways. That's because, on one, with revenue. Some of our taxes are distributed on a situs basis, and depending upon where that boundary is determines where the revenues go. The second half of local option sales tax, wholesale beer tax, hall income tax, and a number of other things are impacted by where the reporting jurisdiction is where that taxes are generated. And as Mayor Huffman was, or Executive Huffman was asking earlier about the hold harmless provisions in 1101, they were very significant to counties. And a part of the discussion at the time in 1998 was what do we need to do to stabilize revenue stream for counties? So to a large degree, counties were providing K through 12 education, and they saw a lot of fluctuations in their revenue stream depending upon whether or not a city annexed certain properties or incorporated. The infamous tiny town law in 1997 that was amended to allow some greater flexibility in creation of cities started off as legislation that was being promoted by the County Services Association, because it started off as a bill that was going to say when a city incorporates, you will not transfer those situs-based taxes until the start of the next budgetary year, because there were some counties that saw a city incorporate in the middle of a budgetary year, and suddenly there was a shift in the distribution of those situs-based revenues from the county government to the city government in the middle of a budget year. So that was something being considered at the time, and the hold harmless provisions of 1101 were very significant because they took an incentive off the table to say a municipality no longer is going to just immediately benefit by saying, hey, we've got a Walmart that opened 3.5 miles out of the city. Let's run down this road like you saw and go out there and grab it and suddenly transfer those revenues from the county into the city. That doesn't go on as much anymore. As was mentioned, a lot of those are starting to expire. I've had conversations with Director Patrick about getting a good handle from the Department of Revenue on that out there and making counties aware of how are there changes going on with respect to those hold harmless revenues so that they don't. You know, we have people, there are not that many mayors in counties in Tennessee that have been serving for over 4 terms, and most of them may be on TACIR right now. A number of you guys are, but a lot of other mayors out there have been in office less than 4 terms, and they don't necessarily realize that their budget's about to be impacted by some annexations happen 15 years ago. But we need to make them aware of that. One thing maybe perhaps the Commission could look at is if we have some places where there's going to be a significant change in revenue, we would ask you all to consider if it's going to create financial hardships, and if it's something that in the review TACIR could look at saying maybe there needs to be a phase-in so we don't suddenly hit year 15 and see a huge drop-off, but we shift over and transition from that revenue returning back to municipalities. So revenue was one thing we're impacted by. The other thing is services, and as Rodney's presentation brought out, that creates difficulty. It's in the interest of the county to have municipal annexations be well thought out, well planned, compact, and contiguous, really related to the growth and related to the services that are being provided. When you have something like he showed in some of his pictures where annexations running down one side of a street and jumping across the other side of the street and grabbing a property and traveling on down further and going back and forth, it creates confusion. It creates difficulty for the highway departments in terms of maintaining things when there are, and I'm going to stick with donut holes because we have a lot of donuts in Tennessee. We don't have very many islands. But when you have those donut holes out there and the highway department's got to somehow pick up and go in and maintain a stretch of highway that's right in the middle of an unincorporated city, that's a difficulty. It doesn't create efficiencies. It's not good for the residents or the citizens or either level of government. So we want to see municipal growth happen in a way that's thoughtful, well planned out, makes a lot of sense, and not be driven and motivated strictly by the pursuit of revenues. Like I said, the change with the 15-year-old hold harmless put an end to a lot of that. And I think some of the requirements and the intent to have annexation and growth be compact, contiguous to tie in with the citizens helped. The example was given and was brought up about emergency services, and I think back at the time when Mayor Shumper was in Knox County, there was some notorious pictures that were shown of some annexations by the city of Knoxville back then that came out in the testimony for 1101, talking about how they sometimes would go through the middle of a neighborhood and take in a house here and a house there, back and forth across the street, depending upon whether or not those people were open to annexation. And you would literally have an accident in the middle of the street, two neighbors kind of get on their phone looking at the front windows saying, oh, we're calling 911, and one's in the city and one's in the county. So they'd simultaneously dispatch the city of Knoxville Police Department and the Knox County Sheriff's Department to come to the same thing. That's not beneficial to anybody. Some of these things that I'm talking about don't really relate to the method of annexation. Some of those I think were being done by ordinance. They weren't by referendum. You could similarly, if you don't have restrictions around it, you could gerrymander an annexation referendum in such a way that you've got a developer that wants somebody to come get this property right out here, and we're going to run around and make sure we get in just enough pro-annexation people into you may end up with a very odd-looking gerrymandered annexation, which is going to end up hampering the efficient provision of services. So I have concerns that just switching one method to another may not solve all the problems like Rodney was bringing out. So the provisions about taxation have really slowed down and really reduced the number of conflicts we see between city and county governments. And I think my experience, so I was working at CTAS as a young attorney in '96 and in '97 when some of these happened in '98. So I saw the battles that were going on before that, and then suddenly everybody went through a really painful, difficult process of sitting at the table together. But then after that, there hasn't been as much infighting between cities and counties. And you see places like Williamson County where there's a lot of people on the same page as far as pursuing economic development, growth, and sustainability and creativity and health in their communities, and they're all on together at the same table about how do we do this in the best way. And there were a lot of places in the state before that you saw people at each other's throats and arguing all the time. So we don't want to see that go away. We want to continue this atmosphere where city and counties get along better. Now I'll say on the other hand, there are a lot of counties out there that say we are still frustrated with some things going on. There's a number of members of our association and county officials that see what they have concerns with annexation and how it happens, and so they would be for this, for things to rein it in. There are other places in the state that are struggling to try to get any kind of growth and development. They're going to say if we can get an industry in here, that's going to be their number one concern. They may be running 15% unemployment, and they're going to say if we can get an industry in here and we need to be able to respond quickly and rapidly to that, and our city can annex it and get utilities there, they're going to be for doing that. So we've got members that are in different places on this, depending upon their local circumstances. If you've had a history of battles over annexation, you're going to say go to referendum. We're tired of fighting about it. If you're struggling with economic development, you're trying to get jobs into your community, and that critical ability of a city to respond quickly and provide utility services to a property, you may have a different priority about things, and you may have some concerns about whether or not that's the direction to go. But that's some of our thoughts on the issue. I said I would ask that as you look at this, you can continue to look at how are we going to make sure annexations are done thoughtfully, services can be provided efficiently, and whether or not a shift in the method of how we do annexation is going to impact that as far as public policy going forward. How are cities going to respond, as Mayor Luttrell brought out with some of the issues on utilities and infrastructure. If we shift over to referendum only, and then we suddenly see all of our municipalities say, we're no longer providing infrastructure out into areas, a lot of counties aren't geared up and ready to do that and to extend that infrastructure out there. Some of them could, but a lot of them aren't equipped to be able to do that. So we'd have to find ways of working with those municipalities or working with our utility districts to make sure we can continue to have that economic development go on.
Well said, Mr. Connor. Thank you. Any questions for David? Mr. Vice Chair.
Thank you, Mr. Chairman. Mr. Connor, do you find, looking at the entire state, that fire protection and ISO ratings enters into annexation consideration?
I think
is that something everybody talks about when this comes up?
I haven't heard a lot of places say that we're going to annex in order to provide fire protection. Right now, we have a lot of places in the state where counties are depending upon their municipalities to work with them and extend fire protection out into the unincorporated area. And we have places where it's done by subscription, or they just have agreements, interlocal agreements between the city and county. There are some counties that provide fire protection on their own, but to a large degree they depend upon municipal fire protection or volunteer fire departments. So if that could be a concern in this issue, if it's an area where the municipality had been providing fire protection and they're going to say we're no longer doing that in the unincorporated area, that's going to require the county to have to take a hard look at whether or not they can step up and provide those services.
We recently looked at fire protection. I think there's as many different types of fire departments as there are people in the state. Thank you, Mr. Connor. Thank you, Mr. Chairman.
The questions? All right, hearing none, thank you again. And we'll move to our final presenter now, Superintendent John Deacons, Washington County. Thank you, and thank you for being here.
Thank you, Mr. Chairman, and members. Appreciate the honor and privilege of being here to represent the County Highway Officials Association and Washington County and Jonesboro. It's 17 years older than the state of Tennessee. So appreciate being here. So while that's being handed out, I'm not much of a speaker. I'm more of a reader, so I want to read my opening statement. And but what y'all were talking about just now about the fire, Johnson City does not provide any fire protection outside the city limits, only for a government building such as a school. And some of the slides I have, that's one of my concerns. So, but I'll get on with my opening statement here. As stated, I'm John Deacons, Highway Superintendent of Washington County, and I'm here to show the difficulties highway officials have dealing with annexation by cities around county infrastructure. As a government official, I realize cities must annex to strengthen their tax base and to recover their investment on their infrastructure such as water and sewer. Washington County residents, not within the city limits, should not be dependent upon the city government to maintain their infrastructure adjacent to their property, and the city should not be able to escape their financial responsibilities by annexing around structures. I will show examples of the inconsistent methods of annexation by Johnson City that has practiced before and after the urban growth boundaries were established. One important factor to keep in mind is Johnson City's paving and resurfacing schedule is 56 years for 327 miles of road. That means theoretically you'll see a road paved once in your lifetime. Washington County's resurfacing schedule is 21 years for 783 miles of road. The city has annexed as much as 2 miles of county road to annex as few as 8 residents, and by doing so, the Washington County taxpayers depend upon the city to maintain the road and the right-of-way. When the residents are called wanting paving or maintenance done on the road, they're informed that this is a city road, and the response is the city can't take care of the roads they have while they annex this road, and they're politely told to call the city Public Works Department. In several cases, Johnson City annexes up to and around structures such as bridges, railroad underpasses, and in one case, de-annexed 40 feet of a bridge, as not to be responsible for maintaining the cost and replacement or deficiencies of closed bridges. Johnson City has, in 2 cases I'm aware of, annexed residents in the right-of-way, and the county road had been paved and maintained for many years, but the city no longer maintains the roads, and Johnson City's response was that the roads did not meet their minimum criteria. Even though the residents are paying city taxes, they no longer have a maintained public road. In 2010, I tried to address the issue with Johnson City of leaving small areas of road between city limits called donut holes and very short lengths of dead-end roads. The city's response was, the city is in recent years attempted to annex on more than one occasion with no support from the property owners, and went on to say that presently our annexation policy is to consider annexing if requested by property owners, or if farmland is proposed for development, then annexation will be pursued. And in 2012, Gray residents were informed that they would, along with working farms, were going to be annexed as the first phase of many in a planned growth area over the next 10 years. None of the residents had been asked to be annexed, as was stated in policy in 2010 during the donut hole issue. After much discussion between the city and the county commissioners, the city did not annex the working farms as stated in 2010 in the donut hole issue. If the city wants to build its tax base, they need to annex the property and the roads in the donut holes where they have infrastructure established. And phase 2 annexation was opposed, and the city agreed not to annex farms, residents, only commercial property, then delayed phase 2 and annex. So if I can get Brett to help me, I'll go through this PowerPoint presentation. I know we're running over here, but Exhibit 1 on strip annexation before UVU was established. In 1994, Johnson City annexed 11 parcels, 8 homes on Will Lane. To do so, the city annexed 4,038 feet of Rockingham Road, leaving 70 county taxpayers on both sides of the annexation dependent on Johnson City to maintain the right-of-way. And that, this is not, I'm sorry, I went the wrong way. But the red arrows show the part they had annexed to get to the black part up there. And what am I doing wrong? That's why I have an IT guy at work. I don't do this kind of thing. But in process of getting to Will Lane before 1994, they had annexed roughly 9,065 feet of roads to get to 29 lots, and later 3,605 feet to a larger development, leaving 203 county taxpayers dependent on Johnson City to maintain the right-of-way and the roads. But that shows the right side shows the red arrows where they annexed, and the blue shows the 2 county roads we have in between where Johnson City had annexed. Exhibit 2, Knob Creek Dock Road. Johnson City annexed about 1,000 feet of road right away, and after a TDOT inspection on a bridge, shown by the yellow arrow there, some minor repairs were required. In 1999, Johnson City de-annexed 40 feet of a 238-foot structure. And that shows the de-annexation, which is by ordinance. Exhibit 3, Johnson City annexed 12,150 feet of CSX Railroad right-of-way to access 61 acres of commercial property. This section of railroad had 2 wooden structures rated critical. Washington County received contracts from TDOT to replace the wooden structures in the 2000 BRZ Bridge Replacement Program, which is 80-20 match. Johnson City was asked to participate in 10% of the 20% match. Instead of paying 10% in 2002, Johnson City de-annexed 12,150 feet of railroad. CSX also declined. The bridges were completed in 2009, 2010 at a cost of $1.1 million each. And this shows where the de-annex between the 2 red arrows. We'll go to the next one. And if you back it up, the two blue, the red arrows show that's where the bridges are. You can see the little notch cut out at the red arrow where the bridge was. They went around the bridge and left it for us to replace. Exhibit 4 is selective annexation. Johnson City has selectively annexed around one-lane railroad underpass, leaving 700 feet of right-of-way on the west side. The red arrow is the underpass. The little white area there on the corner of the black area is the road that was left right there. For Johnson City, it's a Y. On the east side, with a 10 to 15 foot strip on the railroad right of way, if you go to the next one, connecting to two right of ways, Bowman Lane and Fink Drive, to 750 feet of county road. The city and the county are presently in a contract with the 80-20 match with the federal money, STP money, 10% county, 10% city, on approximately a $27 million 5-lane bridge over CX Railroad. The one-lane structure is maintained by CSX. The structure is, the road's maintained by the county, and Johnson City has everything around it. If you go to the next one. You can see there at the red arrow, that's the underpass. There's a 10 or 15 foot gap there between those two black spots that go up to the white area. The R3 was annexed for a church. Then Fink Lane comes down between the crosshairs. Then we have more county road, so we've got county road on the lower side of the underpass. We got it on the east and west side. Then we have another donut hole there, and then on around, it's not there, we have another donut hole. So this is very confusing for law enforcement, and especially for the 911. And so if you go to the next one, that one you can see there, and go to the next one, it even shows a better picture. The purple is the county. So you can see we have 1, 2, 3, 4 different areas. This is just one example right here of what we do. Exhibit 5 in 1990, Johnson City annexed 60 acres and 1,350 feet of developmental road, leaving 810 feet at the end of a dead-end road, which I requested to be annexed. The city's response was that no adjacent property owners requested to be annexed on that portion of road. Well, you can see there, we have to go all the way through the city of Johnson City to get 810 feet of road to maintain that road, which we just paved this year. It cost us more to move the equipment than it did to pave the road. So what is Johnson City saying? They'll annex 1 mile of road to get to 8 houses, leaving 80 non-city residents dependent upon Johnson City to repave their road in 56 years, but can't annex 810 feet at the dead-end road because the county taxpayers are on both sides, have not requested to be annexed. So basically what I'm saying is they have it their way, and I have yet, over the 3-year period, been able to sit down with the City of Johnson City to discuss the donut hole issue. So it is a communication problem. It's something that I'm trying to resolve, and between the fire and the safety and 911, it is very confusing. And if there are any questions, I'll be glad to answer them.
Thank you, Mr. Deakins. Of course, our next speaker is the mayor of Johnson City. No, I'm kidding. Right behind you. No, we want to maintain order and decorum here at TACIR, so we don't have you scheduled. We don't have him scheduled at all. But questions for Ms. Deakins? There is a. I saw Mayor Luttrell paying attention there on some of those donuts. One man's island is another person's donut. Okay. Any questions for Mr. Deakins? Thank you for that. The one you mentioned, the 1990 annexation or the de-annexation, I think you were talking about, was that 1990? I should have asked you at the time. It might have been the
93. There was one in 93 and one in 2002.
Okay. All right. Okay. Thank you, sir. Appreciate it. While we have, it's about time for us to break for today, but while we still have our panelists here, are there questions now for any of them, individually or collectively, by the members? Senator Kyle.
I appreciate the various perspectives on this very difficult topic, and it just seems to me that really, when you're talking about this annexation, you're looking at two issues. One is socioeconomic. It's people like the lifestyle they have, they like where they are, they like what they're doing, they don't want to change. There's nothing you can do to convince them, and we can't really address that with legislation. The other seems to be economic, where we have various and sundry people taking advantage of the other. The question I'd have for though is, it seems to me that we don't want to do anything that would put a chilling effect on development, in the sense that a municipality may not go forward with infrastructure improvements because they don't have any assurance they're going to recoup their investment, and therefore they delay the sewer line, delay what it takes to take raw land and make it marketable, valuable, developable, taxable land, be it residential, industrial, commercial, or whatever. And so I ask you this: if we go to a process of referendum, how do we not have that happen? And I would lead off the gentleman from Fayette County, because you went through where there was more growth quicker than anyone else. What is your perspective on that, if in particular? And I'd be interested in anyone else's. How are we preventing that from occurring? Because you can't, if you don't have the infrastructure, there's no need to. You can't develop the land. You don't develop the land, there's none you need there. It's almost chicken and the egg.
If you could, on the mic, Skip.
Oh, sorry about that. Senator Kyle, at the very least, if on that instance, on that particular scenario, if you had a willing landowner and a willing city, that makes a really good combination to move into it. There, under the current 1101 inside UGB, you can do a strip annexation, because I have a number of them in Fayette County, where they can go down, they take a portion of road or a piece of property in. And if you're dealing with one person, then that makes it a lot easier. A number of the cities do it by ordinance inside their UGB. Outside their UGB, they do it by referendum of a sort, by parcel. Every parcel votes, and I think that's still current. So if there was some sort of scenario like that where you had a landowner, and that was either adjacent or relatively close, that you could get to them, extend it so that they could get their revenue back, they have control over it, that would not hinder the process. All the houses in between, that's just like you said, don't really want to be in a city for whatever reason, be it taxes, because they just don't have somebody else telling them what to do. They need to have a voice in it, but we don't need to stop those businesses, those industries moving in, or whatever we do.
Mayor Luttrell.
Yes, sir. Senator, you've identified, I think, what is the key concern on that whole issue of infrastructure investment, and I don't have an answer for that, because that is the complicating factor. I can only suggest that it's an issue that obviously was not addressed or was not considered during the formative stages of 1101 adoption, that there's some way, somehow, be a subgroup of this committee that can sit down and kind of work through the options as far as suggestions. What I would like to do as it relates to that, because this is an issue that's really come up just within the last couple of weeks with us, that obviously it was not addressed in the formative stages of 1101, that we maybe focus specifically on that resolution. And I would also, the second point that I made had to do with the extraterritorial jurisdictional issues, which obviously were not addressed also in the original 1101. Those are the issues that we're just going to have to dig a little bit deeper on and come up with both a political and a practical solution to it. And I would emphasize that it is a political as well as a practical solution.
Senator Conn.
Well, I just want to respond. We've talked a lot like we know what development is going to happen if you do the annexation. Well, that isn't, at least that's been my life in Shelby County, has not been that way. Essentially, you run that, when you're in the sewer lines out the Grays Creek sewer line, you built it out there, then you waited to see what was going to happen. You didn't know who was going to do it and how they were going to do it and where they were going to do it and what they were going to do, but you knew they couldn't do it if they didn't have that sewer line. Mm-hmm. And therefore, the idea was that I think the city and the county realized land is going to appreciate. Taxes are going to pay for what we did. And that to me, I want this commission and those who are proponents of the referendum, if you don't have control of your environment, I have not seen people who want to spend their money and don't want to make the investment. There's got to be some way for those who make that investment to get their investment recouped. I mean, for the taxpayer who is not directly involved. I mean, I helped pay for that sewer line as much as anybody else did, and hadn't benefited from it at all. And only in the sense that, I mean, directly, we all benefit from our communities doing better. But again, I think you're right, Mayor. We've got those who proposed that need to be able to say the other side of it is if the referendum fails, who picks up the tab? And don't put it in such a way that prevents you from doing that. Because if you do it in a way that if you make it harsh, then people aren't going to go forward. They're not going to take the risk. They're not going to take the gamble. And then we'll be back here 2 years from now talking about how we haven't done anything in 2 years.
Might I add one other point on that? In a sense, through the delivery of services, you are recouping some of that expense. The problem comes in your ability to plan, your lack of a vision and being able to plan for the future and through your zoning process, kind of structure that. A very complicated process, but you all need complicating questions, don't you?
Well, you have to realize we just opened a road that was a line on a map for like 50 years yesterday, I think, out there near Senator Norris's district, where again, which will have tremendous impact on the whole economic area.
Yes, indeed.
Mr. Chair.
Mayor Waters, and then back to Superintendent. Mayor Waters.
Any of you all might respond to this. It seems like we have, everybody's saying we know a way to get the citizens' input into having some say in their destiny, whether they're annexed or not, and that would be a referendum. But then you come back to a point that David made. You can, whoever gets to decide what that area annexed, you can use that to gerrymander whether it's going to pass or not. So you can continue to have this kind of strip business that we've talked about with roads, even in a referendum, unless you address that. And the second issue that I see is this industrial, commercial development issue. If you just purely go with a referendum, and you have a large industry that wants to come into your county, and you've got some land that they're, say, 50 or 100 acres outside, and they've got to have water and sewer and some of these services, and you've got folks between the city that has those services, if the county doesn't provide them, and getting that land, then you're talking about jobs. So I wonder, does anybody have any thoughts about how you balance those two things, the balance of citizen input, having some control on their destiny, and then having the ability for a governmental entity to go out there and provide something that's going to provide jobs for its citizens, incomes for its citizens, and income for governmental entities at the same time. That seems to me to be the crux of what the whole thing we're talking about. How do we get more input from citizens so that they can't strip annex, so that they can't just go out and take these residential areas that don't want to be, but at the same time have an avenue that we can work with cities and other entities to provide services, to provide jobs and commercial development and these kind of things. Does anybody have any ideas on seems like that's the main issues we're talking about?
Brother Deacons, I know you wanted to speak, but on that point, since that's one of the major problems you've been facing.
Well, I mean, I'm not directly involved in the annexation, even though the Gray annexation was very close to where I live. I think Danny Sales addressed that through the soil conservation, but I think a lot of it has to do with the communication, the way Johnson City did address that. They just said that we're going to annex, and the only way they had input was through the county commissioners in that district. And they did resolve some of that by taking the farmland out. But I think that, I don't know what it is, but something's going to have to be resolved on how they go about annexing, whether it be right referendum. But the point I was going to make on the infrastructure is I'm a licensed contractor and developer too, and if you want infrastructure, water or sewer in Washington County, except from Johnson City or Jonesboro, you've got to pay to get it there. And then once you get it, then those county residents, they pay double the water of what the city residents, they pay double for the taps, they pay double for everything. That's how they recoup some of their costs on this infrastructure. And we're very proud of our road system in Washington County. As you can see, 21 paving rotation for 21 years. So I think by strip annexing on the roads by the Johnson City, I think they should be able to take care of what they have before they take any more, especially if the people are not do not ask to be annexed. So that's my stance on the annexation issue, because my place, I'm a fifth generation there. They had it in 1101, and it's too large. I think the county's talked about revisiting it if Johnson City will sit down. We had our farm taken out. So, it's just something that I think that the citizens, taxpayers, need to be educated more on annexation and 1101. I don't think they understand it.
Thank you. Mayor Anderson, since everything is so harmonious in your county, have you had circumstances where by agreement, if you're doing what otherwise could lend itself to a strip annexation where you avoid the road, but you're trying to get to property for commercial development, industrial or otherwise, where by agreement the cost of the road or maintaining the road has been assumed? Is it something that, in terms of good communication and cooperation?
Mr. Chairman, we've had that to happen. In fact, most of our services that we offer in and out of the cities, we have memorandums of understanding or mutual aid agreements. We have, let's see, we have 3 911 centers. We have, to Senator Kyle's comments, the county does not provide any water or sewer. We're not in that business, and I don't plan to get in that business. I'll let the city folks have that. They seem to enjoy it. We have 2 school systems. Franklin Special School District, which serves K through 8, and the county school, which is K through 12. Recently, under the SRO programs in January, the county, through their county general funds, paid for the SROs inside the cities and the counties. I happen to live in an unincorporated area that's being under consideration by Franklin for annexation. We've had 3 or 4 public meetings already, and there's nothing out there but a field. I suspect the Franklin leaders will do what's right, not just to what I want as the county mayor. To answer Larry's questions, specifically, we don't have a lot of industry that wants to come to our community, so I haven't had that firsthand knowledge, Larry. But all the growth we're having is inside Franklin and Brentwood and Spring Hill and Thompson Station and Fairview and Nolensville. And our Achilles heel, I've said this to all the mayors, the things they have to deal with are public safety, law enforcement, and infrastructure. I really don't have to deal with that with the highway department. Now, I do chair the highway department meeting, and to show you the agreements we worked out over there, we have this thing we call in our county, it's called a privilege tax. If you move there, we're going to tax you. It's $2 per square foot. Part of it goes to school, but part of it goes to our highway department. Eddie and the board gave that up this year for us to apply back over to our public safety because we needed it more in our fire department areas. So we do try to work together, and it's not always fun. I can't always say that I'll be mayor. I'm sure the people will make that decision, or I will in time. But in our area it works because we do sit down and we talk. We have monthly meetings. We sit around the table and we try to work out these differences because our community is growing. If we don't demonstrate that, that growth could stop real quick, or our public education will suffer, and we can't afford to have that. That's what drives growth in Williamson County, is our public education. So you got to figure out how to work with it. I've heard all kinds of comments. I don't disagree with your community or your community. I just know what it works in Williamson County. Mark.
Thank you, Mayor. Senator Kyle.
Mayor, are y'all in the majority of in this, when you say we are not in the sewer business and the water business? I mean, if most counties not in the sewer and water business, and most cities are, and that's the way that works, or y'all unique in that aspect?
I don't know that I could answer that. Probably David could.
Senator, I think there may be only 1 or 2 counties that provide any water or wastewater services. It's pretty rare for anybody to do that at all.
So the issue is that we don't want to do anything that's going to put a chilling effect on the development of the sewer and the water, because you can't, if you don't develop the sewer and water, you can't really develop the land. But on the other hand, we don't want to, like I say, if we go to referendum, we've got to do something to where people can know that they're not spending their money on something they may not have control over.
Yes, sir. Mayor Rowland.
Thank you, Mr. Chairman. To anybody on the panel, animal control is an issue that we're dealing with back home. Do any of you in your respective counties, Rogers or any of you, do you have animal control outside any municipality, and how do you do that, if you do?
Well, our animal control is located inside the municipality which we 100% operate.
Okay. Just opposite with us.
We have animal control in Washington County, which is inside Johnson City, and the Animal Control Board in city and county, they just bought a piece of property to build a new facility, if they can raise enough money, private money. And I have 23 cats if you need any.
Well, I don't need that, but wow, that's something I think we need to consider in Cleveland, that the county come in and operated. Thank you, Mr. Chairman.
Mayor Luttrell, do you want to comment on that?
I was just going to say 3 of our communities have animal control, but the county does not.
Senator McNally.
I think some of the horror stories relate to de-annexation, and should the county be able to approve de-annexation by a municipality?
What was the question?
I think
it relates to de-annexation. Should a county be able to approve de-annexation by a municipality?
I think in these circumstances that Rodney and Johnny both described, where the de-annexation is of public infrastructure, strictly for the purpose of transferring it to the county to have to maintain, in those circumstances, I think you should. If you've got something where they're looking at de-annexing a subdivision and residents are going to move out, maybe there's not a place for the county. But if all they're going to do is say, we're going to de-annex that 40-foot strip of bridge so we don't have to repair it.
Well, that was basically the whole biggest part of my presentation was, dodging your physical responsibility for infrastructure. We replaced 2 bridges at $1.1 million each. And, the railroad nor the city would come up with 10%. They just de-annexed 6 miles of railroad. And and I didn't find out about it until I got a notice in the mail from the city of Johnson City that they were going to do it. And, so the whole thing, like I said, it's all about communication. And I think that, I'm still trying to get them to the table to discuss the donut hole issue in Johnson City and Washington County. It's a very confusing, just like that dead end road, 810 feet. The fire department is probably, it would probably take them at least, the closest to one, 45 minutes to an hour, at least to get to that 810 feet of road. So that's the issue I'm looking at too.
Senator, I don't know if this plays into your question, but we had a high school built in outskirts of Brentwood city limit. We pay the tap fees, the water fees, and things like that. There was a bridge that needed to be built over the railroad to get to this high school, and Brentwood waived that for us, ran the water for us, working together. So we've not been experiencing this de-annexation. We just truly tried to figure out solutions to work together. It's not easy, though, but they've done it. And I got to give credit to all of our cities for doing that. Many of our cities write a check to our public school systems inside their district. Brentwood is one of them. Others are there too. The cities write checks on top of what we take out for property tax, because that's the #1 driving element. And it's not about if I win or if I lose, is that we all lose if we blow this animal up. So it works.
Thank you.
All right, thank you all. I don't know if there are any other questions. I've enjoyed the dialogue here and appreciate very much you all participating in it. It's helped us a great deal. If there is nothing further for the good of the order this afternoon, then we will, in anticipation of reconvening tomorrow morning at 8:30, we will stand in recess for this afternoon and see you tomorrow morning. Thank you so much. I believe we can. Yes, we can leave our materials here.
I hear that every day. Yes, sir.
Dick Cochran, I'm Shelby County.
Yes, sir.
I just had a question.